And that should be going live right about now. Very good. I actually started the YouTube correctly today. Not only did I start the YouTube correctly today, but I even put the right title when I started the YouTube correctly today. I feel like that is a accomplishment for this little towel. That said, I initially was going to go live today and talk about what was going to happen going into tomorrow with regard to the Karen Reed and Aidan Kearney 10 a.m. Hearing that's going to be happening. And I thought, okay, I'm going to analyze Aidan Kearney's motion to quash the subpoena that was already issued, and even though the subpoena in question for Aidan's communications with Karen Reed between August 23, a little bit earlier in 2023, and then the fall of 2023, so sometime in the summer of 2023 through the fall of 2023, April of 2023 to be exact, through October, maybe a little bit earlier, of I think October 9th to be exact, or October 10th of 2023, maybe the 11th, Aidan Kearney's communications with Karen Reed. Hey, hello, let me be frank with you and Dixie Doodles. Nice to see you both. So I was going to originally go live and talk to you all about a little bit about what is going to happen tomorrow and why Aidan Kearney filed two very strange motions. One of them was a motion to quash a subpoena that was already served on the special prosecutor in Kearney's cases related to content from the two phones I was just talking about that were searched already in November of 2024 and handed over to Hank Brennan, and then in turn Robert Cosgrove, the special prosecutor in Kearney's case, filed a status update Wednesday night on the docket indicating that there was a USB drive of material and then also this index of the material on the USB drive that was going to be handed over in the context of the Reed case to Hank Brennan because of course Aidan Kearney is on the state's witness list in the Karen Reed trial as a hostile witness, I believe, for the purposes of Hank Brennan moving under Commonwealth v. Mahoney to obtain a consciousness of guilt instruction against Karen Reed by way of a theory of witness intimidation sustained in the context of a joint venture with Aidan Kearney to intimidate said witnesses. And in that context, Kearney's phones, Hank Brennan motioned under Lampron, which is a doctrine or a case in Massachusetts, when a record is not held by the prosecutor, because Kearney's case has a special prosecutor, so the Norfolk DA, who is prosecuting Reed's case, doesn't actually have access to the searched phones in Kearney's case. Brennan had to file a Rule 17 motion to compel production. Now, Brennan won that Rule 17 motion last week, and then a judge in Norfolk Superior Court ordered Special Prosecutor Cosgrove to turn over 3 categories of records related to Kearney and Reed's communications, and that status report, along with the USB drive, was filed last night, Wednesday night. That led to this flurry of strange motions from Kearney, which is what I was initially going to talk about today, because the order that came down from the judge once Special Prosecutor Cosgrove turned over that status report and USB drive, the order basically came down from the judge that the parties were to appear as soon as possible. Now, that was before Kearney filed this motion to quash the subpoena, although it was already served and the data is already turned over pursuant to a protective order, which is on the Reed docket. That was before Kearney moved to do that, and before Kearney moved for this other strange protective order, which I think is a little bit redundant, and I think he more just wanted to shit-talk Kate Peter a little bit, but, I'm not going to knock that. At the same time, what's really important, though, is that this order from Judge Stitsky, I think Stitsky, I think it is. I spelled it with an L one time when it was with a K, so I think it's Judge Stitsky. I might be saying that wrong. That order, when it came down related to Bob Cosgrove turning over the contents of Aidan Kearney's phone and a status report about said contents on Wednesday night, demanded the parties appear in court as soon as practicable. And as soon as practicable seems to be tomorrow at 10 a.m. Now, I realize that Kearney then did his own motions related to this, and will be a motion hearing, I'm sure, related to Kearney's motion to quash, and then also Kearney's motion for a protective order. But I think fundamentally, this is about the fact that Hank Brennan already has a lot of these communications, and so there is a very, very interesting. It does say that Judge Doolin is in charge of tomorrow's hearing, but it should be noted that at the last hearing in the Reed trial, it wasn't actually Judge Cannoni who was sitting for for Brennan's motion for access to Kearney's phone. It was a different judge who issued the order, who heard arguments and issued the order. And so really the question going into tomorrow for Kearney and Reed, I think, is, because the trial starts next week, like, is Hank Brennan going to be able to use the material Bob Cosgrove handed over? Now, it's already handed over to Hank Brennan. He's had it since last night pursuant to a protective impoundment order. So I don't know really what Kearney's doing, trying to claw back this material. I think it's a very strange approach for Kearney to take, because it's too late. The material was already turned over and docketed on the Reed case. This seems like a desperate ploy. And then what else is weird is Kearney wants to show up on Zoom. Now, I get Karen's in pretrial prep and such. Maybe all of them are going to show up on Zoom. They don't want to take the time away, but I just get the sense there's something weird going on with tomorrow. But before we even get there, we have to now go through the breaking news that just came up, which is that just on the docket right now, if you've been tracking Karen Reed's federal appeal, that federal appeal, of course, started after Karen's first trial. Karen, as a result of a mistrial in 2024, where jurors voted 9-3 guilty on count 2 regarding Karen Reed being responsible for the death of John O'Keefe while drunk driving at 12:31 a.m. on January 29, 2022, whereupon Karen left John to die in the snow, returned allegedly a few hours later at 5:23 a.m., confirmed John was dead, left the scene again, went to go pick up 2 witnesses, dropped off the murder weapon back at John's house, returned to where John had died on Fairview Road in Canton with those 2 witnesses, somehow saw John's body, Karen that is, through the snow in a blizzard in the dark before the women passed the tree line of the home. And then Karen was sectioned for threats of self-harm by her own parents, whereupon at the hospital her blood was drawn and a BAC was produced at .08 around maybe after 9 a.m. or so. And a retrograde BAC analysis then confirmed that Karen's BAC at 12:31 a.m. that morning was somewhere between .13 and .29, which is 2 to 4 times the legal limit. And furthermore, Karen, after she got discharged from the hospital, then went back to John's home in Canton after calling John's sister-in-law Erin under the auspices of coming to confront John's now thrice orphaned niece and nephew. But instead, Karen didn't really say much to the family when she got back to John's house with her brother, her father, and her brother's wife, Caitlin Bordeaux. Her brother is Nathan. Her father is Bill Reed. All 3 of them are on the witness list for Karen's coming retrial. They get back to John's house that late morning after Karen's discharge from the hospital after John has passed away. Karen and her father spent 15 or 30 minutes upstairs alone on the 2nd floor of John's home. Then Karen and her family collect the murder weapon and then take it back to Dighton. While Karen's on the drive back from Canton to Dighton, Karen calls John's sister Erin and says Karen will have to remember the bad times and she'll probably never see Erin again. Karen, as a result, though, of that mistrial, tried to challenge 100 or 200 years of standing precedent in the United States, dating all the way back to Lawrence v. Stearns in Massachusetts in 1831, and then following through to U.S. v. Tanner in 1985 or so, and then Bluford v. Arkansas in 2011, and then Pena Rodriguez v. Colorado in 2017. All of which just provided this insurmountable wall. And Renico is an important case in there too, but I don't think it bears directly on what we were just talking about. I think that has to do more with the manifest necessity issue for a retrial. But anyway, those 4 cases over 200 years create this very firm precedent about the inviolability of jury deliberations. And Karen, despite very strong precedent, in particular from the Bluford case, where a juror stood up, the foreperson, in open court and said that the jury had acquitted the defendant on some verdicts, but then went back to deliberating, tried to challenge the mistrial from her first case and get 2 of the indictments, 1 and 3, thrown out. That plan failed. Justice Saylor from the Boston Federal Court, in a 28-page decision that we have read on the stream previously together before, just eviscerated all of Karen's arguments. I think there were times where I felt that Karen's use of a collateral attack via a 2241 habeas petition in order to make that appeal, like it even like get standing to make make the appeal was innovative, but there was no real way that Karen was ever going to be able to extend the very narrow exception to the inviolability of jury deliberations as outlined in Pena-Rodriguez v. Colorado, which is very much what I'd call like the 12 Angry Men exception, which is that you can't really pierce the veil unless it's centered around allegations of invidious racial discrimination, which Karen did not have here. Now, as if that were not wild enough, Karen also just added a juror from her first trial, a juror lawyer, to her defense team. So that's a situation. I don't know if it's going to come up tomorrow at 10 a.m. or if it's going to come up next Tuesday when impanelment starts. But just for the federal appellate purposes, so Karen had gone to the federal district court in Boston. She gets absolutely decimated on her appeal, and then she files a motion for stay with Judge Saylor to try to delay the April 1st retrial date in the state court proceedings, the April 1st, 2025 retrial date for the retrial. Judge Saylor swiftly denies that motion for stay. Then Reed goes up to the First Circuit, and then there was a series of back and forth briefs over the past week in front of the First Circuit, and then Reed also filed another stay request with the First Circuit. So the document you are reading in front of you, the reason why it is such an epic decimation of Reed, and she spent a lot of money on this for no reason, is that the First Circuit issued a one-page order denying Reed's appeal of Judge Saylor's opinion. Basically, they're signing on to everything Judge Saylor said, and then at the same time denying Reed's motion for stay for state court criminal proceedings as moot because Reed lost the actual appeal in sum and substance to the First Circuit Court of Appeals. Now, the First Circuit Federal Court of Appeals in the hierarchy is not the court of last resort, but it is the last court where you are actually entitled to appeal to them. What Reed is only left with now is what's called a petition for a writ of certiorari to the U.S. Supreme Court. And doing a petition for a writ of certiorari to the U.S. Supreme Court is entirely impossible. It's never going to happen on this issue. There's no split in the circuit that warrants anyone weighing in on this. The rulings are very clear from Justice Saylor through to the First Circuit. It was unanimous. It was a one-page slip opinion. The Supreme Court is going to deny cert for this basically summarily. There's no way Reed's going to get 4 justices. We examine the Sotomayor dissent in the context of Bluford, and then we realize that what's actually at play here is there. And what Marty Weinberg's doing is, in my opinion, Marty Weinberg is 20 years too early on this issue, because there is room here. If you read Justice Sotomayor's dissent in Justice Sonia Sotomayor's dissent in Bluford, she lost, but her dissent is kind of like the extraordinary dissent, and it kind of previews where the court's liberals want to go with expanding the doctrine under how we think about reviewing juror verdicts ex post facto, not just in the Pena-Rodriguez invidious racial discrimination context, but also in the wider context of just how double jeopardy butts up against when jurors might not understand juror forms or things like that. There's an extraordinary dissent there nested within Sotomayor's dissent in Bluford. And I think that's what Marty Weinberg was saying and pitching this as, well, we only need 4 to get a petition for writ of certiorari, and maybe like this is the kind of thing that would hook Chief Justice Roberts or Justice Coney Barrett. But then you have to realize Chief Justice Roberts wrote Bluford. He literally wrote it. So there's no way he's going to overturn himself. And if he won't appeal on it, then Justice Coney Barrett's not going to appeal on it. And you're not going to appeal off Kavanaugh or Gorsuch, and there's no way you're going to get Clarence Thomas or Justice Alito. So you have all 3. And then it doesn't matter if you get Justice Ketanji Brown Jackson and Kagan and Sotomayor, because you need 4 to get a grant of a petition of certiorari. And so there's no way this is going to happen. It's not going up on the shadow docket, so it doesn't get reviewed by just one justice for review to the Supreme Court. So yeah, in my opinion, this is the end of the line for Karen Reed's federal appeal. This was it. This was the ruling. If you want to know how Little Towel found this, I spent literally 4 days compulsively going on Pacer and paying 10 cents to constantly refresh the page record, knowing that this decision, I was kind of trying to put myself in the mindset of the federal appellate court structure, and I was thinking they're going to be pissed off that Karen added this juror to her legal team. They're not going to want to delay the trial, and I thought we were just going to get a denial of the motion for stay. And then I saw the order go up on Pacer, and it said just like it was a denied order, and I thought, oh, denial of the stay. And I open it up, nope, and you get an order. This cause came on to be submitted on the briefs and original record on appeal from the U.S. District Court for the District of Massachusetts. Upon consideration whereof, it is now here ordered, adjudged, and decreed as follows. The District Court's decision is affirmed. Karen Reed's motion to stay the state court proceedings pending appeal is denied as moot by the court. Just and the thing is, you wouldn't really know it's as brutal as it is unless you knew what you were reading, because it's so nondescript and bereft, and it is convoluted legalese. But if you understand the procedural history of the federal appellate process, as I just enumerated it in the context of the Reed appeal as to the inviolability of jury deliberations, what you're really seeing is the First Circuit here saying that Justice Saylor's learned historical treatise in the form of a 28-page ruling denying Reed's federal appeal at the lower level in the federal district court was exactly on point. Reed had no constitutional arguments of any kind, and the court doesn't even want to, the First Circuit doesn't even feel the need to enumerate why Reed's arguments are so bad. It can just, in a one-sentence ruling, say Justice Saylor was correct, Reed was wrong, we're moving on, stay denied. And that's what happens when you have a bad legal argument in the federal court system. Hello, I see some friends are joining. Hello, friends. Hi, Maui Swift. Good to see you. Hello, Alex. Alex says, TB frantic with the communications that don't exist with David Yannetti will be made public. Oh, we're going to talk about the TB motions. Don't worry. We're getting to the TurtleBoy and Karen Reed hearing tomorrow at 10 a.m. But what interjected as the lead, although I was not expecting it because it literally happened after I had already set up all the software and I was ready to start streaming, all of a sudden I go on the federal appellate court docket for the First Circuit, which is quite convoluted and difficult to find, but I nonetheless had tracked it down a few weeks ago, and boom, right? I knew it was coming. I just had this prescient towel intuition. All day I was clicking this docket. I don't even want to look at my Pacer record to think about how many 10-cent transactions are on there. But I knew it was coming, and I knew they were going to deny it. I expected a 51-page denial. Although there was excellent briefs, well written, although not as strong on the merits, obviously, for the defense, but very well written by the Commonwealth. It was almost like a flex by Caleb Schillinger with the Norfolk DA's office, who wrote the First Circuit federal appellate brief, which we read through on the stream a few days ago. It took like 6 hours because it was 50 pages, but it was worth it. I learned a lot. I think we all learned a lot. I was able to induce that Mr. Schillinger went, I guess Princeton, Yale, or Harvard, and then I was like, no, not Northeastern. And then someone was like, yeah, he went to Harvard Law. And I was like, yeah, I can tell. The man writes like a legal analytical genius on a level that I never could write, and if I was forced to write in line with federal appellate court grammatical and formatting standards, I would tear my hair out, run around in circles, and stop thinking about the law, and I would just go crawl into a hole, and I don't think I could cope with the level of rigidity that is expected of a lawyer who has to practice in the federal appellate system. And you listen to my brain work, how my brain works. It's pretty efficient. It has a good memory. It has good syntactical precision. I still could not do what Caleb Schillinger did in that 50-page brief. It was an exercise in sublime syntactical precision. I love that word, syntactical precision. All right, so let's see. I know we're about to get into the TurtleBoy stuff, but before I do, let me just check a few comments. I'm almost caught up. At least the money's going back to the state. It's kind of funny because Kimmy K says it's kind of funny because the FKRs hate the judicial system, and that's exactly where all their money went. Yeah, that's true. It's beautiful. Yes, early karma. All right, so this Kearney motion, I know that's what a lot of you want to see, so let's pull up that, and we'll read through both of them. There's not a lot to go through today. We're going to do the Kearney motion, then I'll take you back to the very beginning of the day, and we'll just take a quick meander through all the developments that happened today. There were a few motion rulings on a few experts, and then that'll be it. This isn't going to be a monumentally long stream. I'm just going to explain to you what I'm expecting to happen tomorrow, and it's a little bit pro forma in the sense that I don't think anything Kearney will be able to raise is going to prevent. In fact, I am willing to, with 99.8% lay certainty, as I am just a towel and not a lawyer, none of this is legal advice, and you should get a lawyer if you have a question about the law, and you should get a towel if you're striving to find, although maybe in a tepid way, unconditional love in a world that is very resistant and to that what is seemingly an alien concept. Although I don't really think it is. A towel just embraces universal love all day and just unconditional love and just walks around and is just as happy, bubbly towel self. Then I get very confused, I think, sometimes when people are like, Grant, like, like, pay attention, and I'm like, well, I'm just a naive, happy little towel. Oh, like that time I walked in the street and got yelled at by the state police. It wasn't on purpose. I just didn't want to get in the shot of the camera people. And then when I told that to the trooper, he kind of looked at me and was like, I think he's being honest. And I was like, yes, I wasn't walking in the street on purpose. Then he was like, Grant, how have you been? It's nice to see you again. All right. Let's get into this, though, because this, as I mentioned, it's pro forma in the sense that I don't think it's going to have any impact whatsoever as to whether Hank Brennan can call Aidan Kearney as a witness and use Aidan Kearney's cell phone messages with Karen, or any type of communication with Karen Reed in the context of that trial. But let's read the motion to quash, which is docket number 611.1 on the Karen Reed docket. Now, interestingly, it's a motion. Kearney's trying to quash a subpoena served on a state prosecutor who already had the phones and searched them back in November of 2024. So I'm going to predict, I did read this earlier, I think what the argument is Kearney's like, it's a last-ditch effort. He's like, I don't really have grounds to argue that he can't get it because it's already searched, that being Brennan. So I think the only argument I can make is that whatever Cosgrove turned over must not have been in line with the court order, which is just it's such a bad argument because clearly if Cosgrove turned it over to Brennan, it's already in Brennan's hands. The court, first of all, Brennan has to actually get the evidence approved in Reed's trial anyway. But the court is not going to say, yes, Mr. Kearney, you're right. Everything Cosgrove turned over, you get back. Like, no, absolutely not. What the court's going to say is if there are evidentiary issues with the material that Special Prosecutor Cosgrove turned over to Hank Brennan, then that should be addressed in the context of the Reed case. Mr. Kearney, as a third-party intervener, trying to motion for cell phones that were already subject to search in November of 2024, the court's going to laugh scoff at this. This is completely ridiculous. This and the second motion Kearney asked for, which is a protective order, which is already basically being followed, is already ridiculous. And so I think the Kearney's argument ends up being that there must be nothing on my phone, so you should quash the subpoena. And it's like the judge is going to review what Cosgrove turned over. So if that's your argument, let's hope the Kearney has a little bit more than that. Oh, by the way, I saw someone on Twitter earlier reading Kearney's affidavit, which is, I think, attached to one of these motions. And they were like, his lawyer didn't even sign the motion. And I just rolled my eyes, and I was like, lawyers don't sign affidavits that they don't write. And the lawyer, Tim Bradle, did sign the actual motion. So the amount of misinformation that runs around about this Karen Reed case just blows your little friendly towel's mind. By the way, my name is GrantSmithEllis. It's Wednesday night about 6:30. There was other breaking news today, too. I don't know if you all saw. We can take a quick moment of levity here. If you look on Towel's Twitter feed, which I'll show you later when we scroll through the day's review, I had reported, unrelated to the Karen Reed trial, I do a little bit of government oversight in Massachusetts, I suppose you could say, in the context of the Cannabis Control Commission. I reported that agency had lost track of, or a number of license fees totaling close to $2 million had gone missing. That's taxpayer money, folks. And just today, the state's Office of the Inspector General, after an extensive investigation dating back to July of 2024, confirmed that $1.7 million in license fees at the CCC did indeed go uncollected. And I reiterate, that is your taxpayer money. And Little Towel, got assailed, not verbally, by the government, by the CCC, staff and commissioners, for months related to my reporting about those missing license fees. And now Towel stands vindicated. Once again, standing here, and I get to tell you all that I was prescient, not only prescient in my reporting in that regard, but the government attacked me verbally, and I am now vindicated. God damn you, Cannabis Control Commission. One time I reported on the CCC covering up serious internal allegations of abuse, and then they wrote a press release calling me racist. And first of all, nothing about my reporting even approached that. I actually reported that in the context of the abuse. One of the people had yelled at female staff members and pounded their hands on a table, and somehow the CCC turned that into an allegation of racism against me, which just goes to show you that agency, in particular the press staff, who I always try to compliment and say nice things about, is very petty, and they really don't like Little Towel, even when I'm 100% right. So when I come over to the Karen retrial world and all the different sides are like, Grant, God damn it, why must you always be right? I'm like, well, just go talk to the CCC. They'll tell you that they're very grateful that Grant is no longer their problem. But the CCC should not think that. They should not think that, because I am keeping a close eye on them very much. As much as they would love me to be so swallowed whole in the Karen Reed trial build-up that I am unable to pay attention to the OIG doing things like releasing a report confirming $1.7 million in missing license fees. No, this Little Towel's mind is, I don't know what this is called, what kind of state I'm in, adrenaline-induced exhaustion. But no, this Little Towel shall continue to monitor the Cannabis Control Commission. Their spiteful press team be damned. They actually tried to banned me from press conferences, and I didn't really go about appealing it right. I tried to use a 211 3 interlocutory appeal on the grounds that the SJC or the single justice could intervene at the CCC as a lower court, which it technically is an Article 1 court, for the purposes of preventing an abuse of discretion in the context of a core constitutional right. And then I argued that there was a case from the 70s related to press access to the White House. And I argued that there's an enumerated right through the 14th Amendment via the Fifth Amendment and the First Amendment for a reporter to have access to governmental press conferences. But they didn't get to the merits, the single justice, because the 211.3 wasn't the right vehicle. What I think I should have done in hindsight was maybe like a 231A, I think it's called, petition for a writ of certiorari. I should have treated it like a review of an administrative, and by the way, this is a different kind of writ of certiorari than at the Supreme Court. I should have treated it like a petition for a review of an administrative decision, and I should have petitioned the Superior Court for a review of that administrative decision. But, I'm just a towel, not a lawyer. All right, let's read. That's enough digressions about my reporting into the Cannabis Control Commission. All right, so here we go. This was now what's weird is this motion was it was docketed as filed on 2/18 or 3/18/25, but I didn't actually see it go up, and I would know until yesterday or the day before. I think it went up middle of the day or right before. So I'm not really sure on the exact timeline of when this was docketed, why it took so long to go up, but let's take a read. Intervener Aidan Kearney's motion to quash subpoena. Now comes Aidan Kearney by and through his attorney and respectfully requests that this honorable court deny the Commonwealth's motion for records from dockets 2482 CR 00043 and 2382 CR 0000313. Those are Kearney's indictments in Norfolk Superior Court for felony witness intimidation, conspiracy, picketing, and then wiretapping, and then also another witness intimidation charge related to both Karen retrial witnesses and also independent reporter Lindsay Gattani, who in the fall of 2023 was given information by Aidan Kearney confirming that Karen Reed and Josh Levy, the then U.S. attorney, had a direct connection. And as a result of Gattani being exposed to that information, she inadvertently ended up in the middle of a proxy war, and Karen ended up pushing Aidan out of her inner circle due to pushing Aidan out of Karen's inner circle due to the information revealed, in my opinion, by Kearney to Gattani about Karen's connection to the federal government in the context of the now confirmed disclosed federal probe into the death of John O'Keefe. And then at the same time, Kearney, due to his actions on 12/23/2023 at Gattani's apartment, was had his bail revoked and declared himself a fugitive from justice over the weekend of 12/23/2023. Karen Reed, according to Kearney in a leaked group chat from May of 2024, told Kearney that she was upset at him, and that she told Kearney not to go to Lindsay's apartment on that night, and that she was going to that Kearney's actions were going to make Karen look bad and become a distraction. After Kearney got out of jail on a bail revocation sometime in February of 2024, Karen Reed, in a text on March 4th, 2024, said that she viewed Aidan as a risk, and that the state police were able to search and seize Karen's phones, which are also in evidence and subject to a review by a taint team, and were subject to their own motions earlier this week related to Karen and David Yanetti's contacts between 1/29/2022 and 2/2/2022, wherein Karen allegedly, potentially, told David Yanetti that she hit John O'Keefe with her car, but not that hard. Karen blamed Aidan Kearney's discussions and leaks to Lindsay with being the reason why there was a search warrant for Karen's phones. And the reason why Karen did that is, if you read the search warrant affidavit to Karen's phones, which are very easily accessible on my Twitter feeds and elsewhere, you will see that cited throughout are both evidence from Natalie, who was an intermediary between Karen and Aidan in the summer of 2023, and who's also on the witness list for Karen's upcoming retrial, and also testimony or evidence from Lindsay Gattani about Aidan Kearney's relaying to Gattani, in fact, direct verbatim quotes at some certain points, what Karen Reed was relaying to Kearney about Karen's relationship with the federal government in the context of that now confirmed as closed federal probe into John O'Keefe's death. So you have to understand the multi-layered dimension of the relationship between Aidan Kearney and Karen Reed. It's very tense. I think it's very parasitic, mutually parasitic. They really feed off each other in a negative way. And in some sense, I don't really think Karen views Aidan Kearney as a virtue or as a benefit. I think she now has to manage and handle him. And he's I think it got to the point where once Aidan Kearney started causing collateral liability in Karen's criminal case, and once I think Karen's lawyers put together that the consciousness of guilt motion this time was going to be centered around Mahoney's joint venture theory, witness intimidation, in particular related to Karen Reed and Aidan Kearney's communication, that's when Aidan Kearney started having this demeanor of being quite scared and quite nervous. And so this, heading into tomorrow's hearing at 10 a.m., this motion from Kearney is really a last-ditch effort, because if this fails, adding Aidan Kearney's lawyer, Mark Betterow, to Karen Reed's legal team failed, if this ploy fails too, and those messages, and Brennan gets the messages related to Kearney and Reed's communications and tormenting witnesses, I mean, it's over. Kearney will become an albatross for Reed. Brennan will parade Kearney up on that stand, and there won't be a single juror, in my opinion, who will be able to walk away from that case thinking anything but that Karen Reed and Aidan Kearney are terrible human beings. That's where we're headed, folks. If trials are stage managed productions, because if you want to know the reason, it's because we don't trust the jury to process evidence. So we screen it all ahead of time. And wouldn't you know it, I see the way the winds are yet blowing. But let's keep reading this motion. It's not very long. There isn't very much to it. But as I'm reading it, I'm going to try to give you as much context as I can as to, one, why it's pro forma and going to be denied. Maybe it will result in a discussion about whether all the material turned over to Brennan is in line with the court order. But really, it's not going to work. The order already entered. The judge issued the order pursuant to Rule 17 in a written memoranda. And then you want to try to quash it afterwards? The judge is just going to say, I already issued my order on this. It was narrow in scope, related to your communications over a specific period of time with Reed. So, in support of his motion, Aidan Kearney states the following. On June 9, 2022, the defendant, Karen Reed, was indicted by a Norfolk grand jury for second-degree murder in violation of the statutes for manslaughter while operating under the influence, second-degree murder, leaving the scene of personal injury and death in violation of, and you can tell Bradel wrote this because the other lawyers don't write the charges that way. They don't write injury/death. That's very informal. Alan Jackson wouldn't write it that way. David Unetti wouldn't write it that way. And I don't think Tim Bradle's a bad lawyer. I just think he's like a working lawyer. Like one time I saw him like in the courthouse, like with just a defendant, just like working a case. And yeah, Unetti and Jackson do that too. But they're older. Maybe they're similar, but I think Tim Bradle's a little younger. They're the caliber, maybe because they have like better staff firms or something, but just the caliber of their legal writing. Now, listen, I am biased against Tim Bradle. I have been paying very close attention to that bar council proceeding, and that's the kind of like the allegations potentially that Bradle or one of the people involved in the proceeding with Bradle may have tried to manipulate the board of bar council and the hearing officers in one of Bradle's disciplinary proceedings alongside another prosecutor named Hank Brennan from a case 20 years ago that resulted in an innocent man, Sean Jenkins, spending 15 years in prison due to material misstatements and false evidence and things like that done by the prosecution, paying witnesses to like round-trip airfare for testimony and just withholding evidence that the victim in the case had a drug debt and was being like pursued by this drug dealer who was very clearly the real killer. But yeah, so I wouldn't say I have a bias towards Tim Bradle, but if I'm commenting in my opinion of him as a lawyer and I'm trying to analyze a document he's written, it's informed by the fact that I also think he's done some things I very much think are concerning. But just the way he writes is not, it's just very, I don't know, it's boring legal writing. And it's very, I'm going to leave it at that. On March 5th, 2025, the Commonwealth filed a motion requesting Special Prosecutor Cosgrove to produce to the Criminal Clerk's Office of the Norfolk Superior Court 1 cell phone extraction reports and all underlying data from 2 phones searched pursuant to the search warrants as outlined on pages 15 to 16 of Commonwealth v. Aidan Kearney, the original indictments. So we are talking about, right, so and then that was the Commonwealth's initial motion from Hank Brennan. But no, here's the thing. That already was ruled on by the judge. I mean, we'll pull it up. But the judge's ruling already I can't believe I'm going to have to go bring up this judge's ruling. What are we trying to revisit the underlying ruling? The requested records are not relevant to any issue that would be properly before the court in the retrial. There is no nexus between the purported information sought and any alleged witness intimidation by defendant Reed. Commonwealth's promise to file motions in the future claiming to seek the admissibility of this information is insufficient to establish relevancy for Rule 17 purposes. It is also a tacit admission that the entire effort is nothing more than a fishing expedition. Wait a minute. If the Commonwealth, how can you be saying this when the judge already entered the order? If the Commonwealth is able to file the motion and serve it to Mr. Kearney's counsel, the issue may someday be ripe for adjudication. Until then, the motion must be denied. Commonwealth already tried to indict Mr. Kearney and Ms. Reed for witness intimidation and or conspiracy to do so and was rejected. Well, Kearney has been indicted, but they're talking about the March 2024 grand jury there, and that was clearly before more evidence came forward. And also, you don't need an indictment to get evidence under Lampron. Accordingly, there is already an implicit finding by a grand jury that this charge lacks probable cause. No, it doesn't, because how do you know if the evidence has developed? And should not be admitted into evidence at the Karen retrial. What? Brennan hasn't even made his consciousness of guilt motion. What are you trying to argue? Mr. Kearney respectfully states that the Commonwealth seeking of these records is simply a fishing expedition. The purpose of mass rule criminal procedure. Oh, he already lost this. So that's what I think this is. I think this was his initial. When was this docketed, Mr. Bradle? Yeah, I think this was his. Okay. This was Bradle's initial opposition to Brennan's request, and Bradle lost. I get it. And so the court's ruling already came down. This was just, so let me get the ruling, because now I understand. It was just a late docket. I was so confused procedurally, because I was like, this has to be related to the initial order, right? Because the judge would have had to read this. So what I'm going to do is I'm going to get the court's order for Kearney's cell phones, which I know I have at the ready because I remember when it came down. And then what we're going to do is we're going to review. Here we go. I got it. When did this order come down? Yeah, okay, so this was just Bradel arguing before the order came down. Yeah, exactly. Sorry, I'm trying to find the actual full motion. I thought I had the full motion at some point. Maybe I do. Let me see if this is it. Yes, I have the full one. Thank you, Dee Dee. I think Dee Dee was the one who actually helped me get the full motion. Here we go. All right, so just so folks understand, and we'll go through this again. We just read Bradel's argument, right? That was from the 18th. Okay, so folks, all day we're trying to figure this out. I now understand what it is. It was Bradel's argument in writing before Judge Sidisky, I'm going to have to hear this judge's name said in court because I cannot pronounce that name. It's very difficult for me for some reason. That was before this order came down. Okay, all right. So now that the order has come down and the records are already turned over, I see what's going on. And let's just remember, we don't need to read the whole order, but let's just get ourselves caught up. And remember that after Bradel made that argument, the court made a decision that the motion from Brennan would be allowed in part. And then here's the discussion. I just want to see the judge, whether he tears apart Bradel. And I think what he ended up doing was a compromise that strongly favored the Commonwealth. The Commonwealth seeks data from 2 cell phones belonging to Mr. Aidan Kearney that were seized and searched pursuant to search warrants issued in connection with 2 criminal cases against Mr. Kearney. In those cases, among several other charges, Mr. Kearney is charged with multiple counts of intimidation of a witness. The witnesses in question are individuals who are either witnesses or related to witnesses in the instant above captioned matter. The Commonwealth argues that certain data seized from Mr. Kearney's cell phone from the time period of April 1, 2023 through October 5, 2023 is relevant to and has evidentiary value in the current case because 1. Defendant Reed had ongoing communications with Mr. Kearney during this time period and shared with Mr. Kearney defense theories, materials, and other evidence from her case, sometimes through secure messaging applications and through an intermediary, and such communications include witness information, home addresses, grand jury minutes, autopsy photographs, and the like. An inference can be made that the parties encouraged Mr. Kearney to personally attack witnesses and their family members, that's a quote, with a sole purpose to embarrass, intimidate, harass, and deter those individuals from testifying. 3. The Commonwealth intends to use the data concerning certain communications found on Mr. Kearney's phones relating to such alleged witness intimidation in light of the defendant's ongoing communications with Mr. Kearney as evidence of the defendant's consciousness of guilt. The Commonwealth also argues that these materials are not otherwise available and that it cannot properly prepare for the trial without the production of such material, and that failure to obtain them through this request would tend to unreasonably delay the trial. Given the proper procedure for allowing Mass Rule of Criminal Procedure, Lampron, and Commonwealth v. Dwyer govern the proper procedure for allowing pretrial access to certain third-party records that are not in the Commonwealth's custody and control. Footnote. The Commonwealth has suggested that it may not even be required to seek the order it currently requests from the court in order to obtain the records at issue, given that the data it seeks is currently in the Commonwealth's possession, albeit in separate criminal cases governed by another special assistant district attorney. The court declines to address the validity of this suggestion at this time and addresses only the Commonwealth's argument in support of the Rule 17 motion. So that footnote is basically saying there's this question here of whether the walled-off nature of the special prosecution of Kearney means that this motion was required. And the court's saying, I'm not even going to address whether Brennan could have just gone and got the records. I'm going to just I'm going to set that issue aside. I'm not going to, maybe in another time that will come up. But here, I'm going to treat this as just a Rule 17 motion. Which, frankly, is the right thing for the judge to do, because that's quite a naughty, K-N-O-T-T-Y, legal issue. The Special Assistant District Attorney statute. Because really, Brennan, I think, is also a special assistant district attorney. All right. Such records may only be obtained when the moving party establishes good cause, satisfied by showing 1, that the documents are evidentiary and relevant, 2, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence, 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend to unreasonably delay the trial, and 4, that the application is made in good faith and is not intended as a general fishing expedition. So let's see how the judge ruled. At the hearing before the court, March 5th, 2025, The Commonwealth orally significantly narrowed the scope of its request for data called for in its motion, such that now before the court is only the Commonwealth's request for the following data extracted from the two phones in question. 1. Communication between Aidan Kearney and any witness or family member of a witness involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, and Elizabeth Proctor. Pictures of video depicting evidence of intimidation of a witness of any witness or family member of a witness involved in the murder of John O'Keefe, to include but not limited to same people. Data evidencing dissemination of data depicting evidence of intimidation of a witness of any witness or family member of any witness involved in the case, and then same thing. The court first addressed, so just so folks realize, now I realize what happened. It wasn't that the judge had Brennan win in part, it's that Brennan narrowed his scope, and that's what I think the judge ends up ordering. So the first addresses if you're wondering, what did Hank Brennan get from Special Prosecutor Cosgrove? It's anything that fit under those three categories of information, and we'll see more at the end. The court first addresses the Lampron requirement that the Commonwealth demonstrate that the requested materials are relevant and have evidentiary value in the current case. The Commonwealth argues that the requested data is relevant as consciousness of guilt evidence. Indeed, the defendant's own conduct, this is Karen's conduct, whether sending text or other messages and information to Mr. Kearney related to Mr. Kearney's alleged acts of witness intimidation, would seem relevant under the circumstances. I agree, Judge. However, the Commonwealth's request commands the production of far more, even in its narrowed scope. Oh, I see, so the judge narrowed it more. The request requires the production of data far beyond just Mr. Kearney's communications with the defendant. The Commonwealth's request, as presented, would scoop up an entire universe of Mr. Kearney's own messages, photos, videos, and communications with others, with no regard to or limitation based on whether Karen Reed knew or was involved in such communication. As to that type of data, the court finds Commonwealth has not met its burden as to showing its relevance or value in the current case under Lampron. With regards to Lampron's other requirements, the court finds that the Commonwealth has adequately shown its need for the now further limited subset of data in question as it pertains to the Commonwealth's prosecution of the case, namely that it cannot properly prepare per trial without such materials and that such materials are not otherwise procurable. The court also finds that the request has been made in good faith, that the failure to obtain the materials may tend to unreasonably delay the trial. Accordingly, the motion is allowed in part such that the court orders the Norfolk County DA, specifically Special Assistant DA Robert Cosgrove, to produce from the two previously identified cell phones that were obtained through search warrants in connection with the two criminal cases currently proceeding against Mr. Kearney, any and all evidence of communications between the defendant and Mr. Kearney concerning 1. Communication between Mr. Kearney and any witnesses or a family member of a witness involved in the case involving the murder of John O'Keefe, to include but not limited to pictures or videos depicting evidence of intimidation of a witness or any witnesses or family members of a witness involved in the murder, the case involving the murder of John O'Keefe. And then data evidencing dissemination of data depicting evidence of it. So it's whether Karen and Aidan talked about, whether Aidan talked with family, or yes, exactly. Oh, wow. So that Brendan probably got a lot of material if it is indeed there. And there's also redundant ways. Obviously, there are redundant ways to confirm probably not the actual substance of the messages between Kearney and Karen Reed, but what Kearney was saying to Karen, if Kearney was relaying that to third parties, and then there's even some scintilla of evidence on Kearney's devices, or maybe Karen's devices, confirming what Kearney was saying to third parties, that's even worse. But yeah, so based on this order, it seems like what we're going to be talking about tomorrow, and the judge in the case will have obviously reviewed the documents, is just, it's not Kearney trying to fight it. It's over. It's just whether the material Cosgrove turned over is in line with these paragraphs. And I assure you, Bob Cosgrove, who used to be a judge, did not just willy-nilly turn over documents. If those documents were turned over, it's because they fit within those enumerated categories. And so the judge is just going to say, Mr. Kearney, no, Brennan can have these documents. They're within the categories. Maybe they raise issues about one or two niche, like, is this really within the category? That might be what a little of the argument is about. But on the whole, the Kearney doesn't stand a chance. Drop my water bottle again. These documents are coming in. All right, now, there's another thing that I want to look at here, which is Kearney. And this I don't really see the point of. Kearney moved for a protective order over the documents to have Cosgrove not be able to share more than what was in the documents, more than what was allowed under the court order with Brennan. And it's just such a weird thing to do because, one, Cosgrove already handed over the index and report, and Brennan moved under Rule 17. So Brennan and Cosgrove are already showing their good faith for the procedure they're going about to get these records into the Reed trial. But then the other thing is, if you read this motion for protective order, it's more just like, fuck Kate Peter. And, I mean, fuck Kate Peter. But not for, I don't necessarily know, I don't know enough about all these underlying cases. I know about some of the details, because Kate Peter used to work for Aidan Kearney way back in the day. They're both kind of like, I don't know. Kate's like a Timu version of Aidan, I suppose, in a lot of regards. What the fuck do you want from me? But they've used very similar tactics, and they really don't like each other, and they're both like internet nerds, but Aidan has a larger following, but Kate does First Amendment auditing. I don't know. I think they're both Republicans, frankly, which is fine. There's nothing wrong with that. They're both a little bit bigoted, in my opinion. Like, Aidan doesn't like trans people, and Kate talks about her own, in front of me one time, she misgendered her own kid and was pleased to do it and laughed about it, and I was what the fuck is wrong with, I didn't say it to her, but I looked at her and was what the fuck. But anyway, these two really don't like each other, and each side of the Reed case, at one time or another, I think got tactical use from either Kate Peter or Aidan Kearney. And that's why there was so much hostility and tension for a long time. I really do think it was this toxic cult of personality surrounding Peter and Kearney. And, but I also think that there are very, very interesting dynamics at play with regards to whether Kate Peter was working for a PI firm run by a guy named Marty Kraft, who was whether that firm was itself in the orbit of the investigations of the Reed or Kearney cases. And really what Kearney ends up arguing in this motion for a protective order is whatever's on my phone shouldn't go to Kate Peter. Which I'm just is that what you're thinking about? Whether Bob Cosgrove and Hank Brennan are going to give something very damning from your phone to Kate Peter? First of all, while I think some people talk to Kate Peter, like Brian Tully, Jen McCabe, whatever, I think the actual system, Kate Peter is charged with multiple felonies. One out of Stoughton District Court, I think, for witness intimidation, or one out of Dedham District Court, maybe a misdemeanor RO violation there, maybe the felonies in Dedham. Then there's another felony out of Leominster District Court. All these cases are open. And you got this, so I don't exactly think the system is pleased to be associated with Kate Peter. I think she's just like any other fucking informant or whatever the fuck, or useful operative. I was watching a documentary the other day that was and it was some explication of the early rise of the CIA or the FBI or the early days of those agencies. And they were yeah, of course, if you're going to monitor its subversive groups, you got to have connections in the underworld, And I was oh dear God, the government just runs criminals as fucking informants just all over the place. And that's why so many criminals are untouchable. That was my realization. I was just oh dear God. But then, I've also heard it said that these different apparatuses of government, to be effective, they have to understand how criminals think, and they have to have networks out, the informants out in those networks, and they have to have people monitoring those networks. I just think it opens the door to a lot of Whitey Bulger, John Conley situations, you scratch my back, I'll scratch yours, help me avoid this. And I don't like that element of it, but I also don't really know what to do about it, because prosecutorial discretion gives very wide latitude. But what we're going to read about in this protective order, I mean, there's some limits, in my opinion, to what you can disclose about ongoing investigations. And I think Mr. Kearney is a polemicist in a lot of ways, and weaponizes narratives for personal gain. But at the same time, there are kernels of random truth in some of the things that he says. And Kate Peters' cozy relationship to some of the investigators involved in these cases he's not wrong about that. He's not wrong. Kate Peters, people may hate it that I talk about it, but it wouldn't be fair to me as a towel for people to say to me, Grant, your insights and your perspective on the Karen Reed and John O'Keefe case are so important and so valuable. And then when I step forward and say, okay, well, I also want to provide to you my analytical insights and framework for understanding and unpacking the dynamic between Kate Peter, Aidan Kearney, and the investigators of the Karen Reed and Aidan Kearney cases, and then you tell me, no, we can't go there. I immediately know what the fuck you're up to. And I'm like, it's not that you don't see my insights as valuable. It's that you're conflicted and you don't want to fucking hear it. Well, I don't fucking care. It's not my job to make you feel comfortable in that sense. As to the people that you like not being exposed for doing bad things. If that was the way that I did my reporting, I could not function. Because I would not be able to go into any environment, because every single person who had a friend would just be like, well, Grant, this person's my friend. Why can't you just look the other way? And then I would get pressured all the time. So instead, I'm just like, fuck you. Okay, if you have a problem with what I'm reporting and it's on merit, bring it to me and I will listen to what you're saying. But if your argument is just, I don't want you to report about someone because they're my friend, fuck you. I don't give a fuck about your friend. Or frankly, you, in the sense that if you're telling me you must alter your reporting, Grant, then I'm going to say I do not give a fuck that you want me to alter something just because you know someone. That really gets me up in arms. Now, most people don't do that. In fact, very rarely does anyone approach me trying to get me to do that. But there are some people who, by proxy, have attempted to do things like that, and they don't get a good they don't get a good reaction normally from me in terms of the way I think about their motives and how I'm covering what they're doing. All right. We haven't even mentioned Kate Peters' name, and I'm already going on a rant. Before I read this protective order, let me go ahead and just check if there's been any comments. Oh God, yeah, a lot of you are going to get to listen to me rant about Kate Peter. Let's see. Trevor McIntyre says, hey, Grant. Hi, Trevor. Great to see you. I always appreciate your insightful, erudite, and learned commentary on these streams. Why is TB appearing via Zoom, says Julia T. I don't know the answer to that question. I think that it might have a little bit to do with tomorrow could be very bad. I think it's going to go very poorly for him. I think we might even not get to hear some of the content of these messages based on how this is all playing out. I don't know if it's afraid of jail. I think it's more just the what the content of the phones would be. Trevor McIntyre says, oh my God, the First Circuit didn't even allow oral argument and just denied with explanation. Caleb Schillinger's brief was a dagger to the heart. Absolutely true. Trevor McIntyre and I were sitting here for 6 hours. There were some of you who did the full 6 hours with us. We read through that entire 50-page brief. I don't know how many words 50 double-spaced pages is. 25 single-spaced pages, let's assume 500 words per page, 5 times 25. 5 times 20, 125, add, how many zeros? How many pages was that? Add 2 zeros. So maybe 12,500 words? Is that about right? Is that 500 times 50? It might be even fucking more than that. I don't know. No, more like 25,000 words. I think we read a lot of words. It was a lot, but it was excellent reading. And yes, I agree. The First Circuit read Caleb Schillinger's brief and Judge Saylor's argument and said, Karen Reed, you are wrong, and then didn't even want to hear argument. Let's see. Ashley F. said I think TurtleBoy, called in to a lie from his car last night looking like a fugitive. I don't really know what that means. I didn't see the clip, but okay. It's Thursday, Grant. Did I say it was Thursday? I think I said it was Wednesday. Good job, Grant. Oh, for the CCC reporting. That money goes to education in my state. That must mean you are from Colorado, Ashley, because that I think there's a dedicated levy. By the way, did you know Towel helped to create a dedicated levy on in Massachusetts that helps reinvest some of the adult use tax revenue for the purposes of helping local mom and pop companies owned by people harmed by the drug war start up their businesses in the form of grants, low interest or no interest grants and loans. Well, grants only right now, from $25,000 to $500,000, and that fund gets replenished yearly because it's a perpetual dedicated levy. Well, I am a towel. Someone said, Grant, how do you find the time to do these shows if you're going to law school? Well, I don't know if any of you read my Instagram or my Facebook or my LinkedIn, but it's not just that I'm covering the retrial. I cover regulatory agencies and the civil courts and like lawsuits between like regulators and the appointing authorities. I cover like companies going into receivership, which is like a court proceeding. I cover a lot of like employment-based lawsuits, workplace safety issues. I cover a lot of like things related to like the actual methodology involved in testing cannabis, qPCR, PCR, plating methodologies for testing for total yeast and mold. I try to like oversee like the way the regulatory framework at 935 CMR 500.000 and 001 is kind of like actively implemented, which is the adult medical use cannabis frameworks, because I helped work on the underlying statute and I helped reform it via Chapter 180 of the Acts of 2022, which started as Senate Bill 72 of the 2021 General Court. But anyway, that's kind of irrelevant to the point, which is just, I don't know, when people ask me, like, how do you do X thing? I'm like, well, I mean, yes, I'm doing this, but if I could just do this, that would be very pleasant. It's the combination of school, which is kind of like a hobby for me, law school, and then the cannabis coverage, and then the civil courts, and then the corporate proceedings. There's a lot that I keep in my brain, and I find pleasure in explicating it for you all in an interwoven historical mosaic that is like a practical application of a philosophy of history. So, I don't know. I guess I was reading this overview of my writing that, I don't know if it was like a blog post or like whatever, and someone's like, Grant seems like he has a polymath intellect. And I was like, well, I am interested in a lot of subjects. Let's see. Jeff Williams says Karen Reed wiped her phone. Yeah, that wouldn't surprise me if Karen, after she knew the search word went out, wiped her phone. Kim Corto says, hi, Grant. Thank you, as always. Amazing coverage. Thank you. Great to have you, Kim. But back to that comment by Jeff Williams. That search warrant for Karen's phone, right after it got issued, I think there was a leak from Stoughton District Court, because Karen mysteriously, right as the warrant got issued, but before it got served and the phone got taken, Karen disappeared to Florida, which is where David Yannetti and also Karen's friends, Kat and that other guy, have property. David Yannetti's sister, I should say. So I think Karen avoided that search on purpose by going to Florida. Jeff Williams says, can't wait till tomorrow. Kim Corto says, Grant, will you be there tomorrow? No, I'll watch. I mean, I will watch online, but I have class for another month, and I am at my absolute maximum with classes. So in terms of missing classes, so I have to go to every class from now until the end of the month, and I'm going to do that. So I will be watching if I can, but in terms of actually like being able to get there and get to class and whatever, no, I can't do both. I have to get to school, watch the hearing, go to class, and then do the rest of my Friday. Let me be frank with you, says, I keep thinking of the Cats in the Cradle, but then Bradle. The Cat's in the Cradle with the silver Bradle. That's hilarious. Maui Swift said, no, Bradle is older. Oh, interesting. Let me be frank with you. Says, hi, Maui Swift, Bradle does not behave like that, though. Maui Swift says Bradle's rough around the edges. Yeah, I agree with that. Jackson, maybe a little older. Jackson's in his 60s, I think. Bradel been practicing same amount as Yannetti. Bradel is a 1992 cum laude graduate of Suffolk University. Oh, law school. Oh. Yannetti began his legal career in 1989. Jackson Pepperdine. So Yannetti's a little bit older. Yannetti began in 89. Jackson 94. So it looks like Yannetti's has been practicing law the longest. Yannetti's actually been practicing law for as long as I've been alive. I think I'm actually 2 months less. So I'm 2 months older than when David Yannetti got his law degree. Got his law degree. Bradel's the middle, and Jackson is the youngest. Mind-bending this is Alex. Mind-bending to think a successful attorney would choose to trash their career reputation for TB and Karen Reed. Money and clout are weird. They're probably better than drugs in some sense. Because drugs are fleeting. But money and influence and connections, I mean, what's the point of doing drugs when you can live drugs? Like your dopamine receptors, when just you have a lot of attention on you and the money's flowing. That's why I think they do it, and just to build a life and be happy. If you chase happiness, you can justify doing anything. Nobody wants to look very deep in Aidan's phones. Yeah, I don't want that job. I bet Kay Peter would want that job. She's a little weird like that. Maui Swift, Alex agreed. Going to the levels they have to try to get their client off is mind blowing. Let me be frank. Laughs. Alex makes me wonder if David Yannetti has been using these same illegal practices his entire career and has gotten away with it. Well, David Yannetti had a very strong track record of getting cases dismissed, and that's all I'm going to say about that. If Yannetti went to Pepperdine Law School, he has strayed far from the values of his alma mater. Where did Yannetti go? No, Yannetti went to, he must have gone around here. I don't know where Yannetti went to Boston Law School? Wait a minute. Boston Law School doesn't exist anymore. I think, did he go to my school? That doesn't sound right. Boston University Law School? If he went to Boston Law School, that might actually be New England Law. Maybe it was some old law school that merged into something else. His sister went to New England Law. Well, someone asked, is Kat still supporting KR? I mean, in the sense that Kat gave Karen Reed $200,000 in the form of a low-interest loan. That's a form of support, I suppose. I don't know if she's still... I don't know any details about right now, but I don't know if Karen ever paid Kat back. I'm sure that caused a little tension. One time, Kat made a post, I think, on social media. She got like a tattoo that was like FKR. It was just like F Karen Reed or something, and people were like, does that mean fuck Karen Reed? All right, let's get back to this motion for protective order. It is kind of ridiculous, this order. I got on that whole tangent about Kay Peter, and then I started reading questions because of how ridiculous this motion is. All this motion is asking is that Hank Brennan and Bob Cosgrove do what they were already doing, which is only turn over to Brennan for use in Reed's trial the material that is subject to the court order that we just read. Now comes the defendant, Aidan Kearney, by and through undersigned counsel, and hereby moves for a protective order pursuant to Mass Rule of Criminal Procedure 14 to supplement the court's March 2025 order allowing limited disclosure of Mr. Kearney's cell phone. Wait a minute. Was it March 20th? 21st? It was March 20th. You got the date wrong of the court's order, Bradel. It's clearly March 20th. God damn it, Tim Bradel. To supplement the court's March 21st, 2025 order allowing limited disclosure of Mr. Kearney's cell phone data and prohibiting leaks to third parties. The defense herein seeks a protective order to provide him security. The defense herein, so that's what? No, that's wrong. The defense to provide it. The defense herein seeks a protective order to provide it. Or you could say the defendant herein seeks a protective order to provide him. That's a bad sentence, Tim Bradel. Very bad. I'm using red X all over this paper. The defense herein seeks a protective order to provide him security, clarity, and mutual understanding of the court's order. An order would ensure the integrity of the transfer and use. It already happened, Mr. Bradel. It was transferred Wednesday night. An order would ensure the integrity of the transfer and usage of the defendant's sensitive cell phone data between the outside prosecutor appointed in the instant case and the case of Commonwealth v. Karen Reed as grounds Mr. Kearney states as follows. On March 21st, 2025, this court entered an order granting limited access to Reed case prosecutors to two of the defendant's cell phones accessed by and searched by police in the Kearney case in November of 2024. Pending... Wait, what? 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 Bradle. What the fuck is this? What? It's just, look at this paragraph. Look at this. It's a period after in the Kearney case, period. And then the top of the next page, no, it just goes to this sentence that begins, lowercase p, pending in the Stoughton District and Dedham District Court against her, as well as felony witness intimidation charge against her in the Dedham District Court. Does this jump out of... Oh, I see. All right. It's not Bradle's fault. Just the way that somebody packaged this series of images. It might have actually been a PDF that I got from combining Twitter images. In that case, it's not Mr. Bradle's fault. It's not Mr. Bradle's fault. It just means that the page that I wanted to read right there jumped down to here. All right, so hold on. Oh, I see what happened. I took page 2 of the affidavit and put it as page 2 of the motion. Well, that's okay. We'll go down to here. Well, actually, you know what? Let me get page 2 of this order. Hold on. I know where I can get this. I bet I just have page 2 of the order as a single image. Because I do want to actually see what Kearney said on page 2 of this motion for protective order. All right, let's see here. Where is this? Did I grab it earlier today? I thought I downloaded them all. All right, hold on. I'm not going to be deterred that easily. We went on a very extensive secondary record search yesterday. That was very interesting. But this one I don't have to go on an actual search for because Dee Dee posted it earlier, and what I can do is just go to Dee Dee's source post. Maybe what happened was that the source post itself didn't have the right images, but normally Dee Dee's very precise. So, all right, let me see. Ah, got it. Wait. No, that's not it. What? Right, the motion for a protective order. No, that was the motion to quash the subpoena. The motion for a protective order might be different. Ah, here we go. I got it. Page 1. Oh, I see what happened. It was one of these convoluted documents. All right, hold on. I got it for you. Wasn't the easiest thing in the world to find, but I have it for you. All right, there we go. No, wait, what? Oh, God damn it. That wasn't the right one either. I'm just having a day here. Why is it so hard? All I want is this single document. All I want is page 2 of the protective order. Not the affidavit, the actual protective order. Come on now. That was the quash subpoena. Oh, here we go. Yeah, I got it. I knew I would find it eventually. Oh, there we go. My skills are strong. Sorry about that, folks. Took me just 1 second, but we got to what we needed, which is page 2. The court ordered 88 Cosgrove, the special assistant district attorney assigned to the Kearney case, to provide certain selected data to the Reed case prosecutors from Kearney's phones. The court specifically restricted the Reed prosecutors to be provided evidence or data depicting evidence of intimidation and communications between Mr. Kearney and Mr. Reed, and the defendant must be made aware, and that the disclosure must be made by Mr. Kearney's prosecutor. Does that cover everything that was in the order? To the provided evidence or data depicting evidence of intimidation of witnesses and communications between Mr. Kearney and Reed, witnesses or family member of a witness. Is that actually what the court order said, though? Didn't we just... No, where's the court order? It's Reed and Kearney's communications about any communications Kearney had with any witnesses in the case or family members. Communications about Kearney and between Kearney and Reed involving pictures or videos depicting evidence of intimidation, and communications between Kearney and Reed about dissemination of data depicting evidence. And then Bradel, in his... No, not the motion to quash subpoena, not that one. This is the protective order. In the protective order, Bradel says that the certain selected data of the Reed case prosecutors from Kearney's phones. The court specifically restricted the Reed prosecutors to be provided evidence or data depicting evidence of intimidation of a witness and communications between Mr. Kearney and any Reed witness or family member. That's not right. That's just a misread. What the fuck, Tim Bradel? That is just not right. That you didn't summarize the court's order at all. And it was only to the extent that the communications were between Reed and Kearney. This motion from Bradel makes the order far broader than it actually is. Tim Bradel, even though you got salvaged on what I thought was a terrible grammatical error by the fact that the document wasn't compiled correctly, this is even worse. The court's going to be like, the prosecutor's going to be like, thanks, Tim Bradel. Thanks for expanding the court's order. It's not going to impact the court's order. In other words, the court order prohibits the Reed prosecutor from shopping for any information themselves by rummaging through Mr. Kearney's phones. Okay, so first of all, it's Bob Cosgrove who was ordered to do the search, not Hank Brennan. Here, the defense is concerned that the history of leaks and exposure of sensitive information and materials to third party in the Reed case may continue in connection with the cell phone data disclosure. And then we'll read the affidavit. In these circumstances, it is entirely appropriate for the court to enter a protective order prohibiting the Kearney and Reed case prosecutors from sharing the information with private individuals, which individuals are uniformly detractors and critics of Mr. Kearney. These private parties have in the past publicly claimed to have access to confidential investigative material, and one is presently under a criminal harassment order. That's Mr. Peter, further prohibiting further contact and harassment of Mr. Kearney. Based on her statements, it appears Norfolk County law enforcement is sharing private investigative materials related to Mr. Kearney's cases with this person, someone who has been found by a court to engage in a pattern of harassment towards Mr. Kearney, such that they required the court to issue orders prohibiting such. And then we're going to go back to the actual order. Where is this order? There we go. Further actions. There is reasonable cause to believe police and prosecutors are also sharing information with other private bloggers. Mr. Kearney notes with extreme irony that such leaks and publication regarding Commonwealth witnesses are considered felonious witness intimidation as charges applied against Mr. Kearney, likely by the very same persons leaking the incident information with impunity. Yeah, no, Mr. Kearney, you went to Jen McCabe's house and her soccer game and yelled things, and that it is not the same, if this is even happening. Number 5, protective orders serve to shield litigants and third parties from unwarranted disclosure and as a practical matter facilitate discovery necessary for a trial. Mr. Kearney requested this court grant a protective order restricting discovery of the documents and the Commonwealth's attorneys to the Commonwealth's attorneys and police, and prohibiting dissemination outside of the criminal proceeding at this time, particularly to an individual restrained by a Massachusetts court from harassing and contact Mr. Kearney, which is Ms. Peter, and other antagonistic private bloggers. Such an order will have no effect on the proper execution of the Commonwealth's investigative duty, and it seems impossible for the Commonwealth to conjure a good faith objection to such an order as proposed herein. Yeah, so that is implicit in all of this. That it's not even Brennan. Brennan got material that Cosgrove searched through. So this motion is just ridiculous on its face in some sense, because Brennan can't go fish through the expedition, and even through the can't go on a fishing expedition through the material. He got a limited set of material through the court order. And furthermore, this has nothing to do with whether the sum and substance of what was turned over complied with the original judge's order. This is just a ridiculous grandstanding motion that I'm pretty sure Kearney just wanted to embarrass Kate Peter. I'm not kidding. That this whole affidavit, and I don't doubt, like I said, there are some kernels to truth to this, but just filing this doesn't actually accomplish anything other than what was already being done. There's no benefit procedurally to filing this. There's already a protective order in the case for the cell phone extraction from Lindsay Catani's phone that got leaked to Aidan Kearney by State Police Lieutenant Brian Tully. And interestingly, the manipulation and leak of that extraction, I'm really shocked Kearney didn't mention it in his affidavit, because when Lindsay's cell phone extraction, a full 15-year extraction of her phone, was in the possession of the state police, but before that extraction was by accidentally leaked by Brian Tully, one of the state police lieutenants who talks to Kate Peter, before Tully leaked that to Kearney's lawyer by accidentally, messages from Kate Peter and Aidan Kearney were removed from that. Kate Peter and Brian Tully were removed from that extraction. Let me reiterate, and Aidan Kearney has confirmed as much as well, and I'm basing this off the reports of his lawyer, Mark Betterow, in court letters. Messages from Kate Peter and Brian Tully, both people, Kate sending messages to Lindsay, Brian Tully sending messages to Lindsay, both of those messages, both categories of messages, but not Lindsay's responses, were deleted from Lindsay's extraction while in the possession of the state police. That is the biggest example possible of the collusion that has been going on over the course of this case. And the fact, by the way, that it took 9 months to get an effective protective order entered related to Lindsay's cell phone extraction, I think is a telling indication that there was some tomfoolery there. And I do think just a lot of people protect Brian Tully. I think he goes back a long way. He's got a lot of friends. I think he knows Jen McCabe, and I think Jen McCabe knows Kate Peter. There's just this weird circle. I don't think it's really the prosecutors. I think it's just like this circle around like Tully and Kate and Jen McCabe. It's just weird. Like there shouldn't be a Discord. I don't think Tully's in it, but there shouldn't be a Discord where all these people are talking. All these like witnesses and like Kate and whatever. Like, it's not appropriate. It breeds this like very weird, like sort of uncomfortable atmosphere with in particular Tully and Kate sharing information. Now, that's what I'm saying when I say Aidan has some kernel of truth to this. Yes, I do think that's occurring, but it's not, has nothing to do with the phones searched and in the state possession and being used by Brennan in the Karen Reed retrial. It's and what's in the sense that Kearney making this motion for the protective order is baseless. But if he's going to make the motion for the protective order, why not use the actual evidence that Kearney himself got, although he can't actually mention it without court permission, which I guess would explain why he didn't talk about this. But he could file a redacted. He's allowed to like motion the court for permission to like and redact some of this. But there is no reason to, which is basically prima facie evidence of collusion between Peter and Tully, to not bring up the fucking manipulation of the cell phone extraction, to remove messages from just Kate Peter and Brian Tully. Why would the state police do that? I could see why they would do it for Brian Tully, but why would they do that for Kate Peter? Unless Kate Peter knows Brian Tully. My God. Some of you just got to think. The two things can be true simultaneously. Aidan could have done bad things, and Kate could have done bad things. Aidan could have done bad things, and the investigators involved in looking into Aidan could have done bad things. It's impossible for people when they think about this stuff to hold them in mutual to hold those two things to be true at the same time. It's much like, although not as extreme, the situation with Michael Proctor and his text about Karen. I didn't know he called her the R word. That somehow even slipped past me. Like that, he called her like Yanetti's R word client or something. That's really offensive. Just incredibly offensive. And the same thing with the colitis stuff. And people, yes, it makes sense that Michael Proctor, we're talking about a woman who was alleged to have killed a cop, John O'Keefe, a Boston police officer. So yes, Michael Proctor was righteous in his indignation. But you still can't say stuff like that. And I think it was hard for people who are supporters of the Justice for John O'Keefe movement and the prosecution to stand up there and say Karen can be guilty and Proctor could have said terrible things. Now, some of us did, very openly. Doesn't mean I think Michael Proctor is a horrible person. In fact, I think that Michael Proctor was very passionate about holding responsible a woman who killed a cop. So I don't hold that against him at all. In fact, I don't see it really as much of an indiscretion, and I hope he wins on appeal when he challenges his firing. But with the Kate Peter situation, it is really hard for people, for some reason, especially the small sort of group of people in her orbit, to see that it's possible that Aidan did bad things and Kate did bad things, and that Aidan and Kate are very similar. And just because Kate happens to share your view on, First Amendment auditors or, other unnamed hidden activities that Kate is doing that are noble, I suppose. They're noble. I think it's a little bit scary to operate in that world, but, more power to you. They're just, they can only see the good, and they can't understand that it's possible for there to be bad. And then likewise, they can't understand how someone who would think Aidan did something bad would ever say that Kate did something bad. And that's really dangerous. That's how you get cults of personality. That's why Aidan's people can never see why Aidan will never say, oh, Aidan did something bad. It's the same thing with Kate. Oh, Kate never does anything bad. And we get this cycle over and over and over again. All right, but now we're going to hear Mr. Kearney talk about Kate, and although there's some kernels of truth, it gets a little bit ridiculous. I am the defendant in the above captioned matter. I have a criminal harassment order against Kate Peter, recently renewed for 1 year in Leominster District Court. She has also been charged with felony witness intimidation against Kearney, also in Leominster District Court. Peter, so that's why I get so fascinated by this. Peter is charged with felony witness intimidation in all this. Peter is also the subject of criminal harassment order protecting a good friend of mine who Peter targeted solely as a result of her being associated with me. I think that's Lauren Murray. Peter is also accused of violating that order 3 times, and there are criminal cases still pending in the Stoughton and Dedham District Court against her, as well as a felony witness intimidation charge against her in the Dedham District Court. I think she flipped off Lauren or something during one of the RO violations that led to the WI charge. All these cases have a special prosecutor keeping the Norfolk DA's office away from the cases. I am trying to protect my friend's privacy and prevent further harassment of her, but if further information is necessary, I will provide it through my attorneys. I mean, I don't really know what to say about that. It's a public court record. These are public criminal charges. Lauren Murray goes to court hearings. I think I saw her the other day. I said hello to her in Meredith. I don't know if I said hello to Lauren. I said hello to Meredith. And then I couldn't express my condolences to Meredith in the moment because there was a lot going on. But I think on stream at one point I even said, my condolences go out to Meredith and her family who are dealing with a tragic incident where their loved one was killed in a drunk driving accident by a repeat offender downtown. But my point is Lauren Murray goes to these court hearings. I saw her the other day, so I don't really know what Aidan's saying, and I think it's disingenuous for Aidan Kearney to be up there saying he cares about protecting people's privacy, because what it's really showing in that affidavit is he doesn't care about people's privacy if they're not his quote friend. And if Lauren ever did anything that Aidan thought was disloyal, I guarantee he would burn her in a fucking heartbeat. I guarantee it. It would not shock me one bit. And I fucking hate that shit. I hate that form of control. I think it's such fucking bullshit. And I'm not talking about Lauren. Lauren can do whatever the hell she wants. If she thinks this guy's interesting and wants to hang around him, good for her. But, there are definitely people that I've spoken to who have told me that there's a pattern there with Mr. Kearney And, for example, I think he had written a blog about Tommy, CPU, at one point. And the blog came down when Tommy became more pro TurtleBoy. Now, what the fuck is that? Like, that to me is wrong. And yeah, it's a small orbit. Like, if you watch TurtleBoy, it's always the same group of people watching. Yeah, it's a sizable audience, 15, 18,000 watching him. But it's always the same group of people. Same group of people talking, same group of people around him, same group of people watching. It's a very niche universe, just like Kate with the First Amendment auditing. And so, I think people, it's like being on, like, an internet website. People think that this niche, insulated world matters. And yes, this case matters. The subjects matter when we're talking about this situation and the different cases these people find themselves in. But it just blows my mind. And I got to just pull myself back here, because the more I think about this, the more it frustrates me. The way in which the justice system gets weaponized in this way. Well, I went on all sorts of tangents there. I was talking about why this toxic cult of personality gets tolerated and enabled, and then I went on a tangent, so sorry about that. Because I was talking about how ridiculous it is that Kearney talks about protecting his friend's privacy. He's really saying, I won't protect privacy for other people. He may as well say that, because he doesn't. And it should be the same standard across the board. Like, if privacy is valuable to you as a concept, it shouldn't just be because your friends want it. It should be because it's valuable as a concept. But I don't think, just my personal opinion, I don't think, like, universal morality is how Aidan Kearney functions. I've always thought of him as very morally transactional. Like, what he's trying to accomplish something, like, he gets fixated and set on it, and he, like, will do anything to accomplish it, and so I don't even think Aidan Kearney would grapple with this concept of, is respecting someone's privacy, irrespective of whether they are your friend, a virtue. I think he would just be like, who fucking cares about virtue? And that's what really bothered. That's what I was getting to. I think it's the same with Kate Peter, who told me to my face one time. She was like, yeah, I don't really care about all that religious bullshit. I didn't say anything to her in the moment, because atheists have a right to be fucking atheists. I don't know, you can be an atheist. That's cool. I don't, that's a religious belief, or the lack of. It's a part of the concept of religious freedom to be an atheist, so more power to you. I'm not. I'm very Catholic. Raised in a Jewish family, but I'm very Catholic. I was like, what the fuck? Say that to Miss O'Keefe, Kate. Let your mask slip in front of her and see what happens in terms of your reputation. Say something like that. Religious bullshit. What the fuck? What the fuck? And that's what I mean. It's just such sanctimonious bullshit from these internet nerds. Wouldn't know a fucking moral value if it slapped them in the face, allegorically. And I feel like a lot of moral storytelling used to be allegorical, sort of direct. I'm not actually saying moral stories can slap people in the face. They are words on a page. But I think in the sense that our moral lessons used to be very, very, very direct, so that people would understand that universal moral values only matter if you uphold them, if we all uphold them. And that's why I just read this sentence and I'm like, oh, really, Mr. Kearney? And did you protect... So when you violated Lindsay Catani's privacy multiple times, over and over and over again, that was just to be mean because she wasn't your friend? It's fucked up shit. And I'm not a judge. I'm just some commentator offering my opinion. But if, hypothetically, if I were a judge judging this case, I would see right through that act. And I would be like, this is a problem. And who knows how these cases are going to play out. Just so folks understand, Kearney is the reason why we're talking about these phones, this side distraction about Kate Peter and the protective order aside, which is really just a distraction and fodder, I think, for the Turtle Riders. The reason why we're talking about these phones is Kearney is going to get called as a hostile witness in Reed's case. And do you know what Hank Brennan can do to Aidan Kearney on the stand? Forget about Hank Brennan's ability to cross people like Frank Salemi, Cadillac Salemi or whatever, which shows he doesn't give a fuck about someone like Aidan Kearney. He'll rip Aidan Kearney's soul out on the stand and then pillory Aidan Kearney up on the wall and then demonstrate to the court and to the jury why Aidan Kearney's allegorically flayed carcass crossed up on the wall is an example of the judicial system functioning at its highest apex. His soul, obviously, flayed on the wall. But the point is, if Hank Brennan can cross Frank Cadillac Salemi, not only will he cross Aidan Kearney, but if it comes to it and Aidan Kearney tries to assert the fifth related to some of these questions about witness intimidation with Karen, Brennan can just give him a limited grant of immunity. It won't immunize him on Kearney on all his criminal charges, but he can just give him a grant of immunity on the WI. And then if Kearney tries to invoke the fifth, he can be jailed until he agrees to testify against Karen. So I just think folks have to keep in mind where we're going here. Like, tomorrow isn't really going to be that important. These contacts are going to Hank Brennan. Hank Brennan's going to be able to meet the threshold for introducing these pieces of evidence and getting the consciousness of guilt instruction and calling Kearney, the consciousness of guilt instruction against Karen, and calling Kearney to make Karen her, to make Kearney her albatross. All of that's going to happen. So there's a sense of, I think that's where the sense of doom comes from for Kearney and the dread, because Brennan can just give Kearney immunity. So Kearney's one hope is cooperation, maybe wheeling and dealing, offering to testify against Karen in exchange for a deal. And I think I even saw Kearney asking his viewers on a live stream a week or two ago what they would think if he took that kind of immunity deal or whatnot. And there's an inkling I have. I can't really put my finger on it. There's an inkling that I have that Kearney would do it, that to save himself, knowing that Brennan could just give him a forced grant of immunity, Kearney would take a deal. But that said, I'm going to keep reading this. We're going to keep talking about, this is somewhat perfunctory, but it is interesting to hear Aidan Kearney talk about Kate Peter. And I also got some kind of a message, so I'm going to see if it's important. Let's see. I wonder if it's someone. What are you asking me? Something specific? Hold on, not going to be able to do that for a second. All right, so Peter, according to her Facebook and her X postings, is privy to ongoing information leaks from the Norfolk DA's office in my and Karen Reed cases. For example, Peter has on several occasions published law enforcement information that has not yet been made public. On October 11, 2024, the day after Kearney was arrested, Peter, on her Masshole Mafia Facebook page, wrote to Reed attorney David Yannetti, "We know you've been involved in Aidan Kearney's little witness harassment game, and your texts with him from phones seized the day before by state police have already been making the rounds." Oh, Kate, why did you say that? Why did you say that? Are there texts on that phone with David Yannetti? I mean, those aren't with Karen Reed, but they could be construed that way if Reed was instructing Yannetti to text Kearney. Peter also knew, as shown by her post on September 29, 2024, that Kearney would be arrested on October 10, 2024. Are we sure these dates are right? Was Kearney arrested in October of 2024? Did you get the dates wrong in this affidavit? Are we sure these aren't from 2023? Did Kearney get arrested again in 2024? I'm pretty sure that was 2023. I don't remember. Yeah, no, there's no way it would have been that. Peter also knew, as shown by her post on September 29, 2023, I think, that I would be arrested on October 10, 2023, by saying October 10th. He knows the deal. Wow. I was, in fact, arrested by state police assigned to the Norfolk DA's office just one day after that assertion on October 11th. She also knew the identities of Janelle Webb and Michelle Littlefield, the police dispatcher and Stoughton Court employee charged and fired respectively in connection with allegations against me before their identities were made public. Wait a minute. Stoughton Court employee, wasn't that where the shit got leaked related to Karen Reed's warrant? I wonder if Michelle Littlefield said anything to David Yannetti about that search warrant for Karen's phone. Peter could have only acquired this information from the state police or DA's office. I don't know, but there's not a lot of background there, so I don't know why Kearney thinks that only Peter could have known that. There are other bloggers receiving confidential law enforcement information against me as well. One, Kevin Linehan, posts as Yellow Cottage Tales and reports over and over that his information comes from, quote, multiple sources connected to MSP, the DA, and witnesses. Why would Kevin say that? Why would you ever name your sources like that? Like, very braggadocio for no reason. And that he gets information from multiple close sources that the MSP and Norfolk DA have been informed that, etc., etc. See Linehan postings attached as Exhibit C. Like, that's not good. You know, I don't... Why do people say these things? Finally, one Jennifer Coffindaffer. Okay, that is a former FBI agent. Identify her as such. Finally, one Jennifer Coffindaffer has been used as a third-party mouthpiece, revealing confidential information for the DA's office. I don't really agree with that. I think there was an email where the Norfolk DA was like, oh, isn't it interesting that Jennifer Coffindaffer is talking about this case? No, listen, Jennifer Coffindaffer knows Kate Peter, and I don't really like fucking Kate Peter. So if I had any reason to tell you I think there's a problem with Jennifer Coffindaffer, I would tell you. I don't really see one. I think, you know, maybe looks the other way a little bit with Kate Peter, but, you know, politics. You know, but yeah, Jen Coffindaffer as a person, I don't think, I think she is very authentic in her views on different cases and spends a decent amount of time trying to educate herself and be a voice for the various impacted victims and parties in these different cases. That's very noble and authentic work. I just, you know, to be involved in criminal trials and covering them, you run into people like Kate Peter and drag you down in the mud. I think that happened with Kevin, too. I think at the end of the day, both Kevin and Jen Coffindaffer and all these different people, the witnesses, the families, they're going to learn their lesson that they got burned by fucking Kate Peter. I think most of them already do. But, you know, some of them still want to keep the peace. You know, they get convinced that in the covering up Kate's actions and behavior in the interest of, you know, pursuing a wider justice for whoever it may be, is important. And, you know, that I think it is important, but they're not mutually exclusive. Justice can be a holistic vehicle upon which multiple ends are achieved simultaneously. And I think that's where some people who get involved, listen, I'm not like a true crime person. I don't cover really true crime. I mostly cover the courts. So it's very easy for me to step back from that whole true crime world and community and say there's something wrong there. Not on every level, but it's very easy for the people who get involved with true crime to get taken advantage of by very insidious forces. Now, Jen Coffindaffer, I don't think is an insidious force. I think she is just someone who's trying to do good work and has to, by the very nature of her job, get involved with cases that are very intense, emotional, and have people like Kate Peter involved. So it's almost like, how do you manage someone like Kate Peter? How do you make sure she's not a liability? How do you make sure she's not doing stupid things like revealing the Netflix documentary 8 months early and then having that blow back and then trying to stage manage things and get people into these documentaries? And it's not about that. For example, I got a message from one of these big documentaries over the summer in my Facebook Messenger. I didn't even see it. And by the time I got back to them, it was done filming. It's not even about you being in these pictures or whatever. One of them, I think the docuseries on HBO got like 6.3 million views. That's like, let's see. So over the past 18 months, I got 110 million impressions or views or something. So break that up. Maybe like 8. That's like a month worth of views on. I wouldn't call myself like a large, probably medium size social media feed. You know, so it's not like the documentaries and all of this. It's not really about being involved in that. It's more about the manipulation of the presentation of information to these different sources and these different film companies and all that to try to tell a narrative that insulates people from accountability. That's what gets me all riled up. And I assure you, I don't need to be in a documentary to make sure you can't manipulate people who are making them. Like, who do you think you're dealing with? Literally write fucking statutes for fun. All right. All right. So I was talking about why I like Jennifer Coffindaffer, and I don't think she's a problem. I just think, she should be a little bit more critical of Kate Peters' behavior, very skeptical of Kate Peters' behavior. Jennifer Coffindaffer was privy to GPS data relating to Miss Reed's vehicle in that case, which she published 2 weeks prior to law enforcement revealing it to the public. She also knew that the DA's office would seek mitochondrial DNA testing in the case 6 days before that was publicly revealed. Yeah. That can easily come from sources. You have no reason to believe that would come from anyone, direct or otherwise. You could just learn that from a rumor. Based on the above, it is clear that the DA's office and her state police assigned to that office are leaking confidential data and will continue to do so with my phone data. All right, Aidan. Yeah, I'm not really buying that. I'm not really buying much of any of what Aidan's laying down here, and I don't think the court is either. And for that reason, what I am going to do is I'm going to get that off the screen. But yes, that does give us a hint as to what tomorrow's Karen Reed trial is going to be about. It does give us just a little bit of a hint. Now, what else I'm able to do for you is we'll do a little bit of a review of the day. There we go. I'm a towel. That's me. Nice to see you all. Thousands of you watching on Twitter again. I don't really understand why. Hey, that's me. I'm a towel. Can I wave it myself? All right. What I do want to do, though, is go through a little bit of a review of the day. I want to get us caught up on all the motions that came down, take some final questions and comments, and then we'll be able to close this down, because tomorrow at 10 a.m. we'll be able to see, this won't, I don't think, necessarily be an explosive hearing, but we should get confirmation that Brennan's going to get access to this material. He already had it via court order. Brennan's then going to move forward with using it in the Reed trial. There's no doubt in my mind about that. But the question will be, at tomorrow's 10 a.m. hearing, will Brennan reveal some of the contents to justify their relevance or Cosgrove? I don't know who's going to be there, if it's Brennan and Cosgrove or both. But that's really what tomorrow, I think, is going to be about. So let's take a look. Actually, you know what? Let's read this post, because I wrote a very good post this morning that covers exactly why these connections are so important. And it's not as long as some of my other posts. I think I actually tried to be a little bit more condensed in my writing. And this really tells the tale of what's going on with Aidan Kearney and Karen Reed and all the interconnected players involved therein. Let's see. I'm going to read some comments here before we do this. I wonder if Karen had her license revoked, suspended. Yes, Karen does not have a license to drive, and I believe she can't drive as a condition of her bail. Karen's friends have interesting criminal histories. They do. Lisa Cox says, hi, Grant. Hi, Lisa Cox. So good to have you with us. Trevor McIntyre says, reading the judge's order, it orders text between Aidan and witnesses, doesn't limit it to just those who are named in his cases. I think that's why Natalie and the 3 defense attorneys are on the witness list. Yeah, that might be right, but I thought it applied mostly to text between Karen and Aidan, but you might be right, Trevor. Diana Natalie, is TurtleBoy being allowed to Zoom tomorrow's court trial? Yes. Diana says, I think he's afraid of getting arrested for doxing Hank's address and phone. He was in his car in a garage every noise he was looking around. He could just be paranoid. Grandpa Munster's multi-track lab. Grant, are you smoking cigarettes or cigars? Cigars. It's actually medication for my colitis. Frank, Karen is not allowed to drive. That's why she needs money to hire drivers. Yep. Hello, Grant in chat. Hello, Angela. Very nice to have you. Angela Whittick. I like your profile picture. I thought that Kate deleted her messages so that's why they were no longer on Lindsay's phone. I've had chats with the other person, deleted all their messages to me, and only mine show. No, for Luck Dragon, you should know that the extraction in the possession of state police was edited, and Kate Peters' messages and Brian Tully's messages, not to each other, but each of them respectively, their messages to Lindsay were removed. Portions of those messages for, I think, Tully, or entire sections for Kate. May have been entire exchanges involving Tully, and then just sections of Peter's. But the point is, yes, it was done in the state police custody. Murder by Maestro. Reading between the lines, Aidan and Karen used code to talk, and he took screenshots that they will claim are not communications, so not available to the CW. No, those are communications. There is screenshots of communications. That's covered by the order. It makes more sense that Kate deleted her own messages. Yeah, but no, I'm telling you. So, Folk for Luck Dragon, the messages were on the extraction. After, again, remember, the phone gets run through a program. The program generates an extraction, okay? The messages were deleted from the extraction. That is like a huge deal. Grant, Murder by Maestro says, Grant, with what we know now of the alternate juror, keeping you out of the courtroom was vital to their plan. We had no real press in the room. Folk for Luck Dragon. I like Kate's videos. She's talented. Folk for Luck Dragon. I don't always agree with the things she says or does, but she's smart. Kathy McCarthy. Why does he call himself a towel? Because the towel from South Park is a robot towel, and it smokes a lot of weed and solves complex social problems. To err is human, to forgive divine. I agree. He's basically saying as Kate is some informant, and the speculation that Tully would remove Kate's messages kind of goes along with that. Yeah. Kate worked for a PI firm run by a guy named Marty Kraft with connections in orbit of the Reed case. Kate definitely talks directly to Brian Tully. Jen McCabe definitely talks directly to Brian Tully. Okay? Like, it's more than just informants. I think these people are friends. It is so weird. No, Kevin's name is Kevin. Kevin absolutely said that Kate Peter was his main source of information. He doesn't hide that fact. Yeah. Yeah. I also think Kate takes people's sources. So even if Kevin had sources, I bet Kate would try to bogart them. Can Aidan avoid testifying if he's checked into mental health treatment? I don't know. Do you have reason to believe that he is? I have no reason to believe that. The Pilgrim Shadow. His name is Kevin Lenahan. Yeah, that's true. It is Kevin Lenahan. Kate calls him that, and Kate calls him Plevin. Yikes. Then Luck Dragon says, thanks for clearing that up, Grant. I get it now. Oh, well, I'm glad to be helpful. I am a towel. But let me explain a little bit about exactly what went down with the history between Karen Reed and Aidan Kearney. I'll give you this background, and then there's two perfunctory motions, and then I think I will have told my tale. Hello, towel friends. If you're craving context on why Karen Reed, Aidan TurtleBoy Kearney, and Hank Brennan are being dragged into court as soon as practicable over Kearney's phones, now in Brennan's grip, buckle up. It's a bombshell, and I've got the historic glass onion peeled back for your morning consumption. Content from two of Kearney's phones, searched in November 2024 after a legal slog, just hit Brennan and Reed's defense overnight via a court-ordered status report and USB drive from Robert Cosgrove, special prosecutor on Kearney's felony cases, witness intimidation, wiretapping tied to Reed's trial, and heroic journalist Lindsay Catani. 4 other phones linger under a taint team's gaze, but those first 2, potentially damaging and explosive. I said on stream, and I'm doubling down. Messages from April to October 2023, Kearney, Reed, Yannetti, Jackson, plus leaks that could torch the sky, and Brennan winning a motion to compel production of contents from those 2 phones is only just the beginning. Brennan's got Kearney's chats with Reed, and Judge Stitzley's rushing a hearing. Stitzley's? I think it's a K instead of a Y, an L there, so Stitzky's. Sisitsky? That is a very hard name to say. I'm going to have to hear someone actually pronounce that before I can get that name right. Rushing a hearing. Why? Consciousness of guilt, folks. A play Brennan's poised to nail. Kearney's subpoenaed for Reed's retrial, and Brennan's ready to shred him. Limited immunities on the table for Kearney, in my view, and his Fifth Amendment's toast as a result. Think Chelsea Manning or Young Thug's Little Woody, jailed for defiance under similar circumstances. Called to testify as a hostile state witness, grant of immunity, refused to testify. Hank Brennan's arsenal? Gretchen Voss's tapes. Reed admitting Yannetti warned of culpability if she struck O'Keefe and Jackson scheming. Hank Brennan's arsenal, Gretchen Voss's tapes. Reed admitting Yannetti warned of culpability if she struck O'Keefe, and Jackson scheming to launder protected court documents via the Brian Walsh case, both recorded in the summer of 2023. Walsh balked. Why she sat on those tapes so long, though, is anyone's guess. Yeah, and asked questions about Kate Peters' relationship with Gretchen Voss. Even Meredith the other day was like, Grant, why do you have to have, Grant, your conspiracy about Gretchen Voss and Kate? And I was like, no, Meredith. I didn't say this, but I read her tweet and said, no, Meredith, Kate Peter and Gretchen Voss definitely know each other, definitely talk. I would even think they'd consider each other friends. It's not a conspiracy. That was like part of Kate Peters' doing. Reed's defenses crumbling. Federal appeal dead. Motion to dismiss DOA. Sally Port video a grainy wash. Her taillights busted thrice on tape pre-CPD. Prior to the video getting to this Canton PD after 5 p.m. that day. And Jackson's I destroyed Jen McCabe brag got him skewered by Judge Cannoni's dry wit quill. But this is more than just courtroom theater. It's a political proxy war. Reed hit Josh Levy's DOJ office in November of 2022 with Yannetti and Jackson spinning misconduct yarns to spark a now confirmed as closed pretextual probe into John's death. Fueled by Rachel Rollins' beef with Michael Morrissey. Rollins was soft on crime, and a 2015 Flemmy Bolger Salemi grudge with Dustin Chow at the Boston DOJ also drove it. That same very playbook got Rollins booted in May of 2023 from the DOJ after she targeted Suffolk DA Kevin Hayden for beating her ally Ricardo Arroyo in a primary for Rollins' old seat. Retaliation on both accounts against Hayden and Morrissey, pure and simple. Kearney, for his part, is in deep too. He was teaming with Rollins to sick Rayla Campbell on Joe Kennedy's 2020 Senate run to help a Biden White House ally, Ed Markey, keep his seat and potentially ward off a primary challenge to Biden looking forward to 2024. And bragging about January 6 convictions shows that there may have been deeper connections at play here than any of us realize, towel or otherwise. Did anyone actually ask why Rachel Rollins was given the job of U.S. Attorney and why the White House may have appreciated Rollins' help in that Markey-Kennedy race? People should. Especially ask why Rollins and TurtleBoy were communicating about Rayla Campbell. And that closed federal probe into O'Keefe's death, it exposed Sandra Birchmore's murder cover-up, and I believe that was the only thing that saved Levy and Rollins from bigger scrutiny for the Reed case fiasco that would have come by way of GOP oversight in the Justice OIG. These phones, in turn, are the fuse. Kearney blabbed to Lindsay Catani about the Reed-Levy connection, got reckless in 2023, and Reed, as documented in leaked text messages, called Aidan a risk by March of 2024, due to his actions related to leaking to Lindsay and his indiscretions on the December 23rd and Aidan's criminal charges. I wonder sometimes, amid the reckoning ruins of this cacophonous chaos, if Karen feels a pang for Lindsay's collateral pain. I'd ask her, given 4 hours to read Karen's soul. On stream, I went full bard. I'm doing it again. While reading a prior post, written as the bombs fell on Reed's war-torn dreams. Karen's facing a Sisyphean reckoning, Jackson's singed Icarus wings toppling her seaport war room. History encroaches, flak towers crumble. She's longing for 99 pink balloons in a Joycean cycle of torment. Hegel's dialectic grinding on. No pity here from me. Karen's a frail figure, watching her pea empire burn to ash. It's Casablanca meets Berlin's last days. Turtles, towels, and titans standing in awe before fate. I want those balloons blue with a black stripe for John, though. So why is this coming hearing explosive? Kearney's phones aren't just evidence. They're Pandora's box. They'll authenticate Reed's desperation. Kearney as her pawn after Voss balked. Tying Reed to a DOJ gambit and plans to torment witnesses that could have toppled months earlier if not for the rightful protective walls cast by Birchmore's shadow. And what I am sure is an ongoing probe as to how the MSP unit attached to the Norfolk DA, the very same ones who investigated Karen, declared Birchmore's death a result of self-harm, despite direct evidence that Matthew Farwell was at Sandra's apartment on the night of her murder, and despite evidence of extensive communications involving violence and threats between Farwell and Birchmore. Nonetheless, Brennan's now got the ammo to obtain a witness intimidation-based consciousness of guilt instruction during Reed's retrial without an underlying criminal charge. FRE 801D2E, Mahoney, joint venture, preponderance standard. And Kearney's forced testimony could expose a web of power plays. Rollins, Levy, Morrissey, reaching beyond this case. The exact thing Brennan exposed during the Bolger trial, as to John Conley taking payoffs from Bolger and the FBI enabling the behavior for years. Brennan literally was Whitey Bulger's lawyer, who, although he asked questions that incriminated Bolger while he was his defense attorney, also ended up exposing how the FBI enabled other serious crimes by enabling Bolger, including some crimes by Frank Cadillac Salemi. This order from Judge Stitsky, is thus not just a shocking last-minute hearing on the eve of Reed's retrial. It's a detonation, peeling back layers of corruption, ambition, and human frailty. The sands of time will judge, and I'm here, towel blunt in hand, to chronicle it. Layer's Black Mass, Capote's In Cold Blood, Shakespeare's Macbeth, Thompson's Fear and Loathing on the Campaign Trail, Kant's Theory and Practice, Hegel's Reason and History, Rousseau's First Discourse, Joyce's Finnegan's Wake, Tarbell's History of the Standard Oil Company, Cortez's Casablanca, Lang's Metropolis, Kubrick's Eyes Wide Shut. Take your pick. Every single layer of history's recursive dialectical circle is made manifest in the sad saga that has become John O'Keefe's legacy. Maybe, however, there is hope yet that a resolution to this chaos is soon at hand. And I will close on this note, as published by myself in a prior post on the topic. This unfortunate situation is history's curse. The best laid plans of turtles, towels, and titans crumble before fate's heartbreaking synthesis. Bittersweet, we cue as time goes by, asking Sam to play it once more, lining the streets to mourn a battlefield scarred by the silent screams of untold innocence. To look away is cowardice. To shy from telling this tale is to evade duty. The true cost of human sin isn't ours to bear. It's etched into the sands of time, a lesson in fragile human frailty, forever carved into our collective subconsciousness of guilt. Good pun for our consciousness of guilt discussion. I feel no pity for Karen in the ruins of her once lavish bunker. No sorrow for someone who turned beautiful, precious human lives into pawns in a political battle of wills. I see only that futile, frail figure watching those last embers of an insidious PR empire burn to ash beneath her brittle fingers. In that vicarious catharsis, I find only tempered solace. I cannot predict the days and weeks ahead, nor do I wish to peer into that ether, fearing the conclusion might crush what little spirit I have left to chronicle this chaos. But I know our souls enter this world blessed with the power to right egregious wrongs. Whether we choose to do so, or let hatred consume us, leading to our own destruction, that's a Richard Nixon resignation reference, by the way, may be our only chance to break free from fate's chains, glittered with garlands of flowers as if to distract us from our bondage. A Rousseau reference. The irony cuts deep. The control Reed craves was always near. Moral liberation demands allocution, contrition, compassion, and apologies. Without them, history judges, exacting penalty sans repentance. That's a Bob Dylan, William Zanzinger, killed poor Hattie Carroll reference. Perpetuating Reed's Joycean cycle of torment, and made manifest in Hegel's unyielding dialectic. Perhaps Karen will find her 99 balloons of hope yet, amid the cacophonous polemical blitzkrieg still unfolding before our eyes. But if I have any say, they will descend from above in blue, as mentioned, with a black stripe for John. Disclaimer, I am not a lawyer. I am clearly a towel. This is not legal advice. Get a lawyer if you have questions about the law. Get a towel if you want to prove unconditional love is the only remaining North Star in a world defined by despair, and apparently a towel's childlike innocence. Thank you for listening to that, friends. I'm going to give you 2 more updates here on what we saw leading up to the end of today. And then, despite the fact that more and more of you continue to watch, we will be done for the day. I don't understand it. I don't really, maybe I have interesting things to say. Maybe you enjoy my rhetorical, syntactical flourishes. Maybe you enjoy my philosophy of history. Maybe you enjoy the fact that I'm a towel. But the fact that you're all here really does mean a lot to me. And we didn't even do any real moments of levity tonight. I didn't even get the chance to remind you all that this is a user-funded public information service. And especially over the next week until I get to the end of the month, I definitely have been relying on your very kind donations. I didn't get a chance to see if any donations came in during the stream. I'm really sorry if I missed some that were sent in. I'm going to check right now. I always feel guilty when this happens. Oh, there was a donation sent on the Venmo, so I want to say thank you for that. It was a $5 donation. That means a lot, and you're helping me pay back my very expensive Pacer bill this month. God bless you. And then there was another donation came in. I want to say a huge thank you for that. That's incredibly touching. This happened the other day. I went for like 3 hours and just didn't look at my phone, and then I felt really guilty that I didn't say thank you to the people who sent donations, so I'm doing that right now. And as I mentioned, you don't have to send donations to ask a question, or I should mention. All of your comments and all your questions, if it's not derogatory or discriminatory, I'll read your comments and questions. But if you do want to help me pay for the streaming software or food, so I don't die, and that my brain, apparently the brain is a muscle and it needs calories to live. I wish I did not need to feed it all the time. I wish I did not need to deal with that, but I need to, otherwise I get these headaches and I get very lightheaded, and it doesn't help with my colitis. So the point is, if you want to keep me fed and alive and paying for these streaming softwares, and hopefully one day this venture will not just be me pouring money and losing money to provide public information to people. But if you like this service, if you enjoy these streams, feel free to send a donation. The information is right above my head. It says Cashapp, the money symbol, GrantSmithEllis. The Venmo is at Grant-E1. And then you can also find that donation information in the description of the YouTube stream. By the way, another important piece of information, I don't know very much about this YouTube platform. I do a lot of my streaming and writing on X and other platforms. But since I've started to use YouTube, I noticed we're going up in subscribers. I'm thrilled that you're all here and hanging out. We're at like 350 people or something on subscribers now. So if you like this video from within watching it, if you like the video and click subscribe, apparently it helps the video and it helps the channel, and you don't have to pay anything for that. You can simply click the button. So thanks. I appreciate all those likes and the shares of the video and the subscriptions. Maybe this YouTube will continue to be something that I can do. It's not really that difficult to do 2 simultaneous streams on X and on YouTube. The only difficult component of it is kind of getting things up and running in the beginning, but I'm slowly mastering that. But that said, I also, I got another notification. So someone sent another $5 donation. You guys are so kind, and it really does mean a lot to me, and it does not go unnoticed. I try to actually respond to each one that folks send. I try to leave a comment or send a message, but if I see them in real time, I will say thank you. And it might be a little delayed from when you send it to when I say it on the stream, but just know I do see it, and it is very touching. So let's see. Karen lost the motion to remove the state witness who will be testifying about the hardness of the ground in front of Fairview Road. I believe that is, what is the name of that witness? Robert Gilman. So Robert Reed lost that motion. Robert Gilman will be testifying for the state. That's a key piece of evidence there. I think people really realize that, Reed losing that motion, because the firmness of that ground and John O'Keefe's head hitting that ground after Karen Reed allegedly struck John with her car while drunk driving at 12:31 a.m. On January 29, 2022, while Karen's car was going 24.2 miles an hour in reverse, caused John to, that force caused John to suffer a head injury, and then compounded with hypothermia after Karen left John to die in the snow. John unfortunately passed away. So that expert related to the hardness of the ground that morning due to the blizzard and other things causing the impact injury to John's head is incredibly important. And then Karen lost, let's see, That was the updated list of motions. What else? What other? So the First Circuit Court of Appeals we already talked about. Wasn't there one more motion that she lost today? There was all those Kearney developments. I kind of felt like one more motion came in. Maybe it was just the loss on that motion, plus all the Kearney documents, and then the loss at the Court of Appeals, the First Circuit Court of Appeals. And then I went over, I will just do a quick update for you now because this I think is important. We can take a look at the current status of all the, oh, by the way, we were talking about Kevin. He did say something earlier that was like, zero evidence makes you special needs. I think that was actually an insult, like using mental illness as an insult, you know, like even though the other person may have used it first or whatever, like don't do that. Like that's not cool. Like it makes me think some of these, and I don't mean like all Republicans say things like this, but it just makes me wonder, like, why is there this like weird, like, oh, who fucking cares if we're bigots towards like disabled people or trans people or whatever? It's like, why do you all act that way? Can't you just not be fucking bigots? Like, isn't that like easy enough towards anybody? It was like Aidan Kearney trying to torment himself to explain that he wasn't bigoted against gay and bi people, just trans people. And I was like, oh, Aidan, you're almost there. Just don't be bigoted against anybody. Let's see. Oh, that's right. I wanted to do the updated list of motions. Got him. All right, so I'm going to scroll through them all. You can see that we have, this is the updated list of motions. There are, within the past week, 2 weeks, there have been 35 or so motions ruled on that were outstanding. 34 exactly. And that leaves us with, how many outstanding motions? 35 through 59. So, 23 or so, but not all of them are actually outstanding motions. Let's take a look at the ones that are outstanding. I guess we can go through all the motions. Why not? A lot of you are watching. I'll reward you for doing so. And some of you have been so kind to send donations that I'll go out and get some. I think I want to go get a Butterfinger bar, actually, because they're on sale for $1 at 7-Eleven. But I'm going to go out and get a snack after this. So since I'm up, I may as well read through them. All right, so the unseal the audio from the sidebar for counsel of record only, that was allowed. The unsealing of the recordings of Gretchen Voss and MetroCorp, that was allowed. The motion for protective order, we don't really know what that is about. It's related to evidence in the case. It was from the state. It was allowed. The limine motion from the defendant to exclude certain witnesses before and after trial, Judge Cannoni ruled this is allowed except those witnesses exempted by docket 576, so Karen Reed's family and John's family. Witnesses are sequestered before and after testimony until the close of evidence. When testimony is concluded, the courtroom is open and no one is excluded. Defendant's motion in limine for view, this is allowed. Counsel need to work out details of exactly how defendant will attend. Defendant's motion in limine to prohibit testimony regarding funds paid to experts for purposes of voir dire, that was allowed by agreement. The defendant's motion for attorney-conducted panel voir dire, denied. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witness once they have taken the stand, allowed as to both sides. Defendant's motion to impound, it's just a motion to impound. Defendant's motion to impound, another motion to impound. Motion in limine to exclude witness, which is Richard Green, I think's prior criminal history, which was impounded and was allowed. Richard Green, I think, was arrested in 2016 for filing a police report in battery or something. Commonwealth's motion in limine to allow in-court identification, allowed. Commonwealth's motion in limine to admit victim's photograph and photographs of the victim's injuries as observed by medical providers on 1/29/2022 from autopsy, allowed. Commonwealth's motion in limine to induce certified records from the R&B from Karen's car, that's a very interesting one. I wonder if she had previous collisions, allowed. Commonwealth's motion in limine of intent to obtain Corey records of jurors, allowed. Commonwealth's motion for offer of proof prior to defendant calling or summoning the Norfolk DA and victim's witness advocate as witnesses and request for an order that neither is subject to sequestration, allowed, no objection. Commonwealth's motion in limine regarding chalks and directing both parties to provide visual presentation in chalks prior to using, allowed. Commonwealth's motion to allow celebrate expert demonstration allowed. Commonwealth's motion to admit defendant's blood draw results from good salmon resulting serum conversion and retrograde extrapolation after hearing allowed. Commonwealth's motion in limine to preclude reference to any alleged bad character, any prior misconduct of the victim or any witness. If counsel intends to introduce this evidence, defendant must provide notice to the Commonwealth 1 week before the evidence begins. Defendant's motion in limine to exclude false and irrelevant statements of Michael Proctor. Commonwealth does not intend to offer this evidence. That was about David Yannetti being in a parking lot of a school with one of the witnesses during the last trial. Defendant's motion in limine to allow counsel to state grounds for objections to promote judicial economy and efficiency and to adequately preserve issues. Denied. So no speaking objections. In Massachusetts, you just say objection. Defendant's motion in limine to prohibit the Norfolk DA and Massachusetts State Police from having juror contact. Ruling. This was a great ruling. Motion based on a false premise. When I saw this ruling, this is how I knew the motion to dismiss was going to be denied. No one other than trial court security coordinates juror security, and no one other than court officers has contact with jurors during trial. Norfolk County DA's office, State Police, Defense Counsel, and media will have no contact with trial jurors. That was different than last time, but everybody better obey that order. No contact with jurors. Defendant's motion to impound Exhibit 1. Yeah, so that was an impound motion. Supplemental admission for Pro Hoc Vice by Mark Betterow. Denied. Commonwealth's motion for a protective order allowed. Motion to exclude the testimony of witness James W. Crosby from the defense. Denied. Commonwealth's motion for records from Aidan Kearney's case. We already talked about those a lot today involving the felony charges for witness intimidation of Reed witnesses, and then also the WI and wiretapping charges for Lindsay Catani. Addressed to Robert Cosgrove, allowed in part. That was the memorandum we read earlier. Commonwealth's motion to compel communications between the defendant and Attorney Yannetti. That was on the messages between 1/29/2022 and 2/2/2022, where Karen allegedly said very incriminating statements to Yannetti, and Karen then talked to documentary producers about what Yannetti told her during those initial conversations about her potential criminal culpability. Commonwealth's motion for records, Unsolved Productions, Inc., allowed. Commonwealth's motion to dismiss for extraordinary governmental misconduct, denied. Defendant's motion to dismiss for extraordinary governmental misconduct, denied. Commonwealth's motion for the buffer zone in order prohibiting signs and clothing in favor of either party or law enforcement, allowed. Defendant's motion to exclude the purported expert testimony of the Commonwealth's proffered witness, Dr. Isaac Wolf, and request Dobert Lanigan hearing, denied. Defendant's motion to exclude certain testimony of Commonwealth's witness Robert Gilman, and in the alternative a Dobert Lanigan hearing, denied. The ones with no rulings. Commonwealth's motion for an extension of time to file motions in limine related to defense expert reciprocal discovery, no ruling specified. Commonwealth's motion to correct the record, no ruling specified. Defense motion in limine to present demonstrative exhibit based on Christina Henley's testimony, no action taken at this time. Defendant's motion in limine to exclude irrelevant, admissible, and prejudicial bad character and propensity evidence. I think that's about the Aruba fight. No ruling specified. Defendant's motion to impound portions of defendant's motion in limine. Yeah, nothing on that one yet. Defendant's motion in limine to exclude serum plasma ethanol concentration. There's no ruling here, but note that the Commonwealth already won their motion on this, so technically the defendant's motion is denied. But it's not actually denoted as denied on the docket. Commonwealth's motion in limine to appoint court stenographer, prevent identification of jurors, and impound jurors' names during trial, no ruling. Commonwealth's motion in limine for sequestration order and for relief from that order for family members of the victim. No ruling, but note that in the prior ruling for mentioning contact with witnesses and such, there was a sequestration order mentioned, so I think this order is going to be granted. All sequestration orders for witnesses are granted. The Commonwealth's motion in limine to preclude reference to and redact the manner of deaths contained on the victim's death certificate, as happens in every criminal case in Massachusetts, because that's not how the ME renders their opinion about the cause of death. No ruling specified. The Commonwealth's motion in limine to admit the victim's out-of-court statements relating to his state of mind, no action taken yet, needs to see how the evidence develops. This has to do with the breakdown in John's relationship with Karen, and John telling family members and others that he was going to end the relationship with Karen. Commonwealth's motion in limine to prohibit when Karen was cheating on John, and Karen thought the kids in the niece and nephew, John's double orphaned adopted niece and nephew, were putting strain on their relationship. John clearly thought the kids were the priority, and so coupled with Karen's cheating and other things, they were falling apart. And I think John was just messaging former girlfriends during COVID or something when he was bored that summer. Someone was saying this, I think, during one of the recent documentaries, and Karen was the only one who responded to him, which is the only reason John, I think, and Karen were together to begin with. Let's see. Commonwealth's motion in limine to prohibit reference to any pending IA investigations, sustained findings unrelated to this case, or unfounded allegations of misconduct. No action taken yet. Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. No ruling yet. Commonwealth's motion for attorney conducted an individual voir dire of potential jurors and proposed jury questionnaire. Nothing yet. Defendant's motion in limine to allow evidence of lack of bias. No ruling yet. And that was trying to say that ARCA's not biased. ARCA's very biased. ARCA and Reed definitely hid communications and payments from the state for an extended period of time and were forced to reveal those communications in my opinion, by new U.S. Attorney Leah Foley turning over information to Hank Brennan that in turn eventually compelled the defense to reveal the ARCA nonsense that was going on. There's no ruling yet on the defense motion for reconsideration of the court's order denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby. There's no defendant's motion in limine to exclude the testimony of Commonwealth witness Dr. Jordan Welcher hasn't been ruled on yet, or the request for voir dire. Commonwealth filed an opposition, though, in recent days, 10 days ago. There's a Commonwealth motion in limine to exclude expert witness testimony of defense expert Garrett Wing. No ruling yet. Commonwealth motion in limine to exclude defense expert Michael Easter's opinion of the investigation. And no ruling yet. Defense filed its opposition 2 days ago on the 25th. There's the defense assented to motion to continue the trial date. That was denied. Judge Kearney said the trial will begin with impanelment on April 1st as scheduled. If a jury is selected before April 28th, counsel can renew the motion prior to the jury being sworn. So if there's a lot more discovery, or now that the federal appeal is off the table, that's not an issue, but it can be revisited. I don't really see it being revisited. And it looks like Judge Kearney thinks it's going to take a few weeks to get a jury. Defendant's motion for reconsideration of portion of February 18, 2025 court order denying defendant's motion to compel production of a forensically sound copy of the 12029 video surveillance footage in law enforcement custody. No ruling yet, but they already lost that. Other interveners, Aidan Kearney's motion to quash the subpoena for his phones. There was no ruling, but he already lost because the order entered, as we know. Others, Attorney Robert Cosgrove's ex parte started status report of Rule 17, respondent filed and forwarded to Judge Sitsky, docket 634. This is not a motion, but note that this will probably come up during Friday's hearing. Then the Kearney's motion for protective order regarding the sharing of cell phone data between Kearney and Reed prosecutors. No ruling yet. And then that is the update, folks. Look at that. We went. More and more of you kept watching. We're almost up to 2,000 of you now. Dropped my water bottle again. I really appreciate you all taking the time, though, to come and watch. It means a lot to me. It really does. It does not go unnoticed by this little towel that so many of you enjoy spending time with me and watching these streams. And even though I do take moments of levity and say hello from time to time, I think we get a lot done. We learn a lot together. I'm going to go over to the comments now before I forget, because I do want to see. Oh, we have some chatting going on. Let's see. Ashley F says, thank you, Grant. Thank you all. The Luck Dragon says, liked and subscribed. Grant is much easier to listen to than try and read his posts on X. Hey, now, I have a syntactical... Oh, I need to find a much better way of putting this water bottle on the side table, because I dropped this thing at least 4 times this show. My post on X, I think it depends on what style. So a lot of people enjoy reading. Some people enjoy listening. I happen to be working on my writing style right now. So what you're seeing me write on X is not just because I'm trying to convey information. The reason I'm writing that way is because I'm experimenting with different writing styles to find a style that I really like. I think I'm moving towards what I like the most, which is just this sort of... It's very inspired by Joyce, but I think it has some inspiration from like Shakespeare's like Twelfth Night, blending high and low kind of commentary. But really what I'm trying to do is an active philosophy of history and capture kind of Vico's recursive synthesis embodied in a larger Hegelian structure. And so the words you're seeing me write on page are me trying to do an active philosophy of history. And it might be a little bit inaccessible. You might prefer to hear me explain it. But all you're really doing when you're reading that writing is hearing my thoughts in real time, but transliterated somewhat slightly into a written package that's designed for consumption by an audience that's somewhat learned. Like, I expect you to go into that text trying to find layers of hidden meaning. If you're not reading those posts thinking, oh, what is that 99 red balloons reference? Is that like to Nenya's song? You know, what is that Garlands of Flower reference? Is that to Rousseau? What is that like flak tower reference? Is he talking about like Berlin's flak towers getting bombed by the Russians and turning into bomb shelters in the last days of the war? Like, if you're not going into it with that mentality, trying to parse out those little sort of rewards for an erudite reader, then yeah, it's not going to be that fun. But if you go into it with that mentality, it's like a really good novel that you're reading for a second time. There are things hiding right in front of your eyes via words that you understand that you cannot pull out unless you're looking for them. That's what I'm trying to accomplish with my writing. And with these videos, I guess I'm being slightly less rhetorical, slightly less syntactically precise. And if you find that easier to consume, wonderful. I do have moments of soliloquy, though, where I absolutely speak exactly like I write. No doubt whatsoever. And in that regard, I'm not really speaking in iambic pentameter or anything along those lines, but there is a sort of poetic ebb and flow or rhythm to the nature of how I deliver my words, just as how I deliver text on a written form, text in written form. Let's see. I see. Sorry, I didn't see your second comment. No offense, Grant, I'm on the spectrum, and sometimes reading a lot at once is overwhelming, and I'd rather listen. Yeah, so I didn't even see that second comment. There may be lots of reasons, as I was saying in my prior answer, why for some people it's easier to listen, why for some people it's easier to read, why for some people it's easier to see. I think all these different forms of processing have different virtues, and whatever one you use to consume information, that's really what's important to me. If you're able to, in whatever form it is, actually engage with and consume the information, then I'm happy. I feel like I'm living up to my greatest good, my summum bonum as a towel, and that makes me very happy. There's another word. There are two words for greatest good. Summum bonum is one of them. I used to know the other one. I don't think it's apotheosis, but it was. There's a Greek word as well for like highest. Eudaimonia. I love that word. Eudaimonia is the Aristotelian concept for like a life well lived, or maybe it's summum bonum is the Aristotelian concept. But there's eudaimonia and summum bonum, both of which reflect like the human asymptotic relationship with perfectibility from a moral perspective, and they just embody this idea of what it is to have a life well lived. And I think a life well lived for me as a towel is conveying information in a form, multiple forms if it need be, that people are able to relate to and understand. And I hope you feel welcome here and comfortable here, and whatever the reason that you enjoy this content, I'm glad to have you with me. No, so someone was like, oh, you have like 50 viewers. I just started this YouTube. There's like 2,000 people watching on the Twitter. I don't really even think about it in terms of the numbers, though, in that regard. I do think it's great that more people are commenting on the YouTube, engaging with the YouTube, subscribing to the YouTube, liking the channel. Even the, like negative comments, it doesn't matter. You're boosting the video in the algorithm by engaging. So I appreciate all the help building the channel. I don't know how long it's going to take to get the YouTube to the same level that the Twitter's at, but we're going in that direction. Let's see. Hi, Grant. Very good to see you, Seema, if that's actually you. Ashley F. says she loves the philosophy references. I appreciate that. I was actually in school for philosophy before I became disabled many years ago. I wanted to study that field very much. I do tend to talk a lot about philosophy, throw in some Platonic references now and again, although I tend to focus a lot more, I'd say, the Kantian tradition, a little bit of Hegel, some John Rawls, but really mostly what you'll hear me talking about is like an applied philosophy of history that mostly comes out of Hegel. It has a little bit of a Joycean overtone to it, though. It's definitely an encoded form. There's a little bit of like Dickens influence too. Definitely Hunter S. Thompson, Edith Tarbell, some film producers too, like Kubrick. But there's definitely an intent on my part. I am intentionally telling you a story in written and auditory form that is layered with subtextual allusions and historical references and literary references. And I'm not doing it to be paternalistic or degrade your intelligence. I'm doing it because all different types of readers are going to be able to find those Easter eggs while going through the text or listening back. It just depends on what they were schooled in, what discipline they came from. And if I do have a polymath style intellect, then yes, it would make sense that all these different peppered references aren't going to be picked up by any specific siloed audience. But I do really like when someone is like, oh, I'm a subject matter expert in, so philosophy here as an example from Ashley, because then I'll be like, oh yes, can we talk about, Father Copplestone's 17-volume work on the history of philosophy, and can you tell me about your thoughts on the tension between continental and whatever philosophy. I don't do as much applied philosophy anymore, but when I was involved in actual philosophy, that was quite an enjoyable time in my life. Now I feel like I have to juggle multiple disciplines simultaneously and then do it in an applied fashion, such as to help engender cogent discourse among the public. And it takes kind of the academic and fun part out of it and turns it more into like a vocation and a calling. But that said, all right, folks, I've read through a lot of your comments. There are a ton of you watching on Twitter, but needless to say, we have reached the end of our evening together. My name is GrantSmithEllis. Thank you so much. I didn't even get to go through all of the donations that came in. The few that I saw, I'm really appreciative that you all are so kind and that you think of me. I'll do this one more time on the way out. I don't do conventional like web-based streaming. I don't do super chats. I pay for broadcasting software out of my own pocket. I pay for the access to the Pacer documents out of my own pocket, and it's all user supported from folks like you. And if you think this is valuable content, whether with a like or subscription or a donation, I hope you'll continue to keep Towel alive and flourishing. Keep those words in mind, folks. Eudaimonia and summum bonum. They are the theme of tonight's stream. No matter how much is going wrong in the world, no matter how much you're dealing with, if there's anything that I hope you leave these streams with, it's hope. Even in the face of challenges or personal struggle, hope that a better world is possible by way of your informed participation in our public sphere. And that, to me, makes me a very happy towel and allows me to lay my head down at night for my few hours of rest in a way that brings solace. So, truly, God bless you. My name's GrantSmithEllis. I'm so glad to have been with you tonight. It means a lot to me to have you here. And I'll see you again, I'm sure. Oh, hold on. I see a few comments. Selmalina said, it's me, Selmalina. Well, there's two of you. Now there's a Sema B and a Semalina 23. Are you both the same people? Greek is really hard to learn. Yeah, ancient Greek's really hard to learn. I think modern Greek's a little bit easier, but it's still hard. I've been to Greece before. I went to Santorini and Mykonos. It's a very nice place. I was able to find ouzo there. It was when I was younger. I was still drinking, but that was the most interesting liquor I think I've ever had. Ouzo, it's a very unique Greek drink. Wait, you didn't touch on John Rawls's Utopia. Well, no. So, Trevor, actually, what I find so interesting about the Rawlsian canon is in Chapter 8 of The Law of Peoples, which was his last work published in 1992, John Rawls frames the Supreme Court as the exemplar of public reason. Now, I loved Rawls's turn after the Dewey Lectures in 85, right? So theory of justice was a bit of a form of hegemonic liberalism that really was like an early precursor of the Bush Doctrine. But if we look at Rawls' Rawls's political turn after the Dewey lectures in '85, and in particular examined political liberalism, there we start to see overlapping consensus and reasonable pluralism and toleration of decent hierarchical peoples, right? But that's not really the issue I have with the Rawlsian canon. I think his political turn and the emergence of political liberalism in '89 was a valid sort of check and balance on the Fukuyama Huntington kind of nonsense that was bubbling to the surface at that time. Very neocon inspired discourse, with Rawls kind of as the progressive outlier there. No, where I really take issues with the Rawlsian canon is Chapter 8 of the Law of Peoples. I don't think it can really legitimately be argued that the Supreme Court of the United States, in their decision-making, in their discourse, in their writing, can be framed as Rawls says, which is really the crux of his whole theory, to be the exemplar of public discourse. Now, here's my fundamental argument against Rawls, and I used to go back and forth with my professors in graduate school all the time about this. My fundamental argument is, if you think about the legal profession, okay, why are you entitled to a lawyer at a critical stage of a criminal proceeding? The real logic, if you read the court's enumeration of this logic, it's that the layperson is fundamentally unable to understand the adversarial process at its most basic level, okay? Like the moment you get arrested, the court just assumes that the layperson has no idea about what is going on with this process. So how in the world can Rawls stand up there with any intellectual credibility and write in Law of Peoples in Chapter 8 that the Supreme Court is the exemplar of public reason? No. I said, nope, that does not make sense. It does not reflect the actual reality. And furthermore, we can do an active quantitative methodology to examine the cogency of public discourse. We don't need an intermediary stand-in in the digital age. You can simply, you run a fucking methodological query on a geo-fenced or based set of data from an API from the public talking on various websites, and you can literally quantify public discourse and then use a comparative methodology against what the lawmakers are talking about to examine whether or not you have a legitimate political system. You don't need to say the Supreme Court is the exemplar of public reason. Public reason is the exemplar of public reason. The difficult part is figuring out how to quantify the cogency of public discourse. And that was what I was very interested in. Well, thank you for the acceptance of the answer, Trevor. I appreciate you prodding me a little bit. Seema, I'm sorry we're not going to get a chance to talk more, but you came in too late to the show. I've been going for 3 hours now, and I was just thanking all the very kind people who sent over a few donations, and I was also saying goodbye. Someone was mocking the fact that there aren't a lot of people on YouTube, and I was like, well, there's thousands of them over on Twitter, but apparently people pick one or the other. But yes, if you're not subscribed on YouTube, I'm not saying this to Selmalina directly, but if anyone isn't subscribed on the YouTube and they want to and give the channel a like, we'll see if we can get this channel growing past 300-400 subscribers. Maybe it'll get to 1,000 one day. I feel like I was just at 120 subscribers like a week ago, and then all of a sudden it went to like 330. All right, God bless you folks. It really does mean a lot to me that you've been here. Oh, someone shared the link. All right, well, I'm so glad you made it, Seema. We'll check in another time. You can definitely come back for another stream, ask all the questions you want. Really appreciate that you checked in, though, and I appreciate all of you who are here. And thank you to Trevor McIntyre for helping me go on that random rant about John Rawls at the end of the stream. What a nice way to package my moral lesson for the day, which is the perfectibility of human souls in the context of the Greek term eudaimonia and the Latin term summum bonum. And if that leads you down a research rabbit hole tonight about how to perfect one's soul through the pursuit of human goodness and rational understanding and universal love, then I've done my job here. All right, this time really, God bless. I'm going. I have to go to bed. Don't you want me to sleep? I cannot just stay up 24 hours a day informing you all about court decisions. I have to sleep. All right, good night. God bless. My name is GrantSmithEllis, by the way. Have a good rest of your Thursday.